All right. The 14A District Court for County of Washington, State of Michigan is now in session. All those having business before the court draw near, the Honorable Judge Jay Secretary to preside.
You may be seated.
Let me get Ms. Londa, your honor.
Yes.
Let's grab a seat at that table, okay?
Okay. Good morning.
Good morning.
You said grab a seat.
Just take the furthest one over.
Okay.
All right.
Gotta be on YouTube, am I?
No, I told him you were not a sovereign citizen, so that's been a particular problem. I shouldn't say in this court, it's in general.
Yeah.
You might be on YouTube if you were driving the car in front of judges with a license.
She has a valid.
My goodness.
My goodness. You can't hide it anymore.
Yeah, people need to watch something else. Get Hulu or something. Okay, are you ready? Court does call the case of the people, state of Michigan versus Linda Donald.
Good morning, Your Honor. Ashley Lonnie for the people.
David I. Goldstein, attorney on behalf of the defendant.
All right, the record to reflect, we had a bench conference in this case, and there's a witness that has been subpoenaed that I think, as the court understands, both sides would like and believe would be beneficial. They have not appeared this morning. And I believe Ms. Londy indicates she can start the trial. I don't know if that would help, but Mr. Goldstein has indicated that this is a necessary witness for him.
Your Honor, that is correct. The witness in question, his name is Kathleen Carroll. At the time of this alleged incident, she was an employee of the community mental health, and she witnessed the events of this occasion. We believe that she is a necessary and critical witness. I do appreciate the fact that Ms. Londy did make arrangements to have her subpoenaed. It's my understanding from the officer that she was subpoenaed and she is not here. And I would like an opportunity to have her produced, because I think she is a necessary and critical witness.
Okay.
And I mean, certainly we could start with the other witnesses, but I think I've always opposed that idea. I like the idea of just doing things at one time.
All I want. Ms. Londy.
For the record,
Closing
Your Honor,
arguments.
The officer in charge, Benjamin Holman, is present. He did make an effort to contact this witness this morning, was not able to reach her by phone, did email her the subpoena. I understood that the email was acceptable to her, so that would be good service as far as people are concerned. I also understand that she has new employment now and has sort of an unusual or crazy schedule, so it may be difficult. I'm not sure why she's not here. So I understand defense's request for an adjournment.
But you've
I've
had
gotten
some
bad
interesting
dates from
Thanksgivings.
witnesses who are present, and I have the ability to look at dates with the court and hopefully pick a date that will be agreeable for the two that have appeared this morning. I'll also state for the record, we do not anticipate the appearance of the named victim in the case.
Got it.
And Mr. Goldstein about that, and we understand that. Happy to talk to the court a little bit more about it. I think as testimony comes in, that may become more clear to the court why that is.
Your Honor, Ms. Londy and I did discuss that prior to going on the record this morning, and I indicated to her I did not even anticipate that individual would be here. So I'm not with that.
Okay, I have
Bloom trial scheduled to
seventh
start in a little bit,
enough time, and is that a bad
like 5 minutes.
time?
Sorry?
The 7th.
Next Monday, I've got a jury trial in circuit court Monday, Your Honor.
All right.
You know how Mondays are, Judge.
How long is your jury expected?
I don't think you heard me, Your Honor.
No, I didn't, sorry.
How long is your jury expected to?
2 days.
2 days. And
We could do, you said you'd like to do it quickly, is that correct?
correct.
What about Tuesday, the 15th at 1 o'clock?
That would work.
Ms. Londy.
I believe so, Your Honor. If court will indulge me just a second.
Sure.
I take it you don't have exams on that day?
I never know. No, I don't.
We do not.
But are we gonna have a courtroom? That's,
Yeah, I will have, at 1 o'clock, I should be able to get in here.
Confirming it now. That does work for the people, just confirming it with the 2 witnesses.
For the record, everybody has sent that to me. I don't want to discuss it. It gets political. I have not seen most of it. I understand everybody's interested. But like I said, it turns political and those issues simply cannot be discussed in public. That's how the world is.
You're waiting on a confirmation text.
I am, Your Honor.
All right. Which some courts, in order to, for example, quite frankly, they're replacing some religious holidays that were, and so they'll take that day, do, say, Good Friday, and not close that day. I'm not saying that's what they're doing, but I know that there's courts that do that.
I'll check with her.
There are childcare obligations at 3 and 3:30 on that date. Could potentially have a slightly earlier time of day on the 14th, 15th, excuse me.
Well, you know what, that's my, what you call it, date, isn't it?
That is correct. I checked.
I'm free anytime of the day. Right?
The people appreciate the court's flexibility.
So because of, well, I'm looking at that to see what I have on that date. If I started earlier, we would be starting in courtroom A, and then we'd be switching to this courtroom because I got to get out of the magistrate's way, and then get
There's no jury, so that shouldn't be. an issue.
that should right.
I don't anticipate this being a 7 or 8 hour sort of. Mr. Goldstein has other thoughts.
No, I think probably a couple of hours.
A 7 or 8 hour trial with David Goldstein doesn't happen.
Sort of not.
Yeah, I don't know if I can get started any earlier.
Well, then, I appreciate the court checking, but I understand.
Okay, why don't we set it and then we can try to get started as quickly as we can and see what we can get through. Non-jury trial will be adjourned to then October 15th, 2024 at 1 p.m. All right. Thank you. And frankly, counsel, if everybody's here around noon and my courtroom is available and I'm
All right.
done,
All right, I'll go
start
fix
early
that.
if everybody's
It's the
good
Bloom
with
trial.
that, but I will set it at 1.
10:15, 1 p.m.
Yes, sir.
Thank you. I didn't understand all the
We do a
boom
staggered
comments till
meeting
now.
Of parties.
That's fine. I need to talk
Today.
to the client anyways. That's fine.
Who do you want to go first? Can the victim? And
Yeah, but
thank you.
So I guess yes.
Mr. Goldstein always very accommodating.
He is.
Then I will ask them to go ahead and leave.
All right.
Looks like Mr. Bernstein got summoned to go spend his time with you guys.
Okay. Go to standing recess.
All right.
Yep, Boomer's gonna boom. It's the Bloom trial, not the boom trial. And yes, everybody asked me about the Judge Boyd situation. I have thoughts. They can't be expressed publicly. I'm not even sure because I haven't seen it all, but I'm guessing my take is not sanctioned by the powers that be. So, you know, I'm not doing it. I'm not doing it. I can't express myself honestly. So I can either lie or just sit there like, yeah, you know, and it's not very entertaining if you're doing that. That's the truth. That's the truth of the matter. And I don't even know if that's the case. I'm just guessing. But no, we're hanging out for the Bloom trial. It came on early. I thought there might be a nugget beforehand. There really wasn't. But why not? We can all just hang out here. Well, Talk with Mike isn't really a political platform. That's just not where I'm at. So I'm not going to bore you with my ideas, which will change 0 minds and not help anything and irritate a bunch of people. Why bother? I need a t-shirt. I need that t-shirt. I can wear it every stream. It's perfect. Or if I had any I could make a banner. Technically it's the only thing I can do. I like it. I think let's make the banner. This will be an interactive Law Talk with Mike experience here. You know what we need for an interactive Law Talk with Mike experience? You know what we need, don't you? We need music.
You can only pray, you get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk with Mike. We got pretrial on the dial. Planning always make your chest smile. The pros say can't ever share a file. Defendants are always in denial. He was not driving, he's traveling. His reasons and facts are unraveling. It's another day on Law Talk with Mike. Courtroom is always popping up. You have a failure appear and you scoff. Judge Simpson is never going soft. Webster is always showing heart. We are heading into that
Thank you.
Summer. Did you miss the line? That's a bummer. The soft six never get smarter than dumber. He's not the man, he doesn't need a number. He was not driving, he's traveling. His reasons and facts are unraveling. It's another
Okay.
day on Law Talk with Mike.
Where are we at here? Oh, that's a lot of me. Yay. A lot of me this early in the morning. Jeff Bloom's trial is on here. I streamed the first part of it. We inexplicitly stopped the trial in the middle of the prosecutor's argument.
We are heading into. There is no schedule at Law Talk Nation. You can only pray, you get a notification. If you're lucky, it's a spicy fornication. It's another day on Law Talk.
So theoretically, we would do the rest of the prosecutor's argument, the defense closing argument, read the jury instructions, and give it to the jury. Bloom was completely out of control through the trial, as is his habit. He started in with the nasty gestures and whatnot. I think we're headed for not guilty in the case. We saw the video. It didn't show much. We heard from the nurse that the incident was related to, and he was okay, but not very compelling. And you've got a high burden. All that adds up to a not guilty, if you ask me. Do I think Jeff Bloom was being a jackass? Yes, I do. Do I think the state has met their burden beyond a reasonable doubt that this was an assault and battery? Maybe. Yes, but barely, and reasonable people could differ on that, and therefore probably some reasonable people will differ, and we're probably looking at not guilty. There's my prediction. Not because Jeff Bloom's a nice guy or perfectly innocent, but because the system we have in place in the United States of America. There's my thoughts. But where's the stream? He's supposed to be starting now. Well, he certainly doesn't do himself any favors. He acts like a complete fool every time he's in court, and thereby just the merest suggestion that he did something wrong is so freaking believable. Because every time anybody has ever seen him in public, he does something wrong. All right, where are we at here? No, this is just too much of me. I can't do this. Not at this hour. Not at this hour. I'd rather see private. I shouldn't have said that with my chat. I'm referring to the word private printed on the screen while we wait for Judge Simpson, people. Everyone relax. Everyone relax. I don't even know if this will come on. This might be another fishing expedition. Thank you. Oh yeah, speaking of which, Iris is in there. Thanks for passing that along to me. And who else did it? And I think Iris was just passing along. Let me look. Let me give credit while we're doing this, because I didn't know this. I didn't know this stuff. It looks like just Bob L. Bay is responsible for this debacle. Thank you, just Bob L. Bay. Also, Bean Slot closing jury trial in Bloom. And then, wait a second. Webster Court Dubois pretrial. Is that going on right now? Should I be going over there? Tell me in the chat. Dubois, that guy, I haven't seen that guy in a while. Let me see if I can hunt that down. So many goofy defendants. It's hard to keep track of them all. And then we also have Eric Martin with Judge Slavin on the schedule. It's an all-star day. It's an all-star day of stupid. It's another day on Law Talk with Mike. Webster's on? All right. Let me see if I can find Webster.
Years, which I am going to pull up that statute, but what's your response to it?
Your Honor, if the court is prepared to take judicial notice of the certified driving record in this case.
I don't have that available, but if counsel agrees that that is his driver's record, does Mr. Cannell have it?
I do, Your Honor, and as I noted for the court, I don't see that on there.
In the interest of time, do you want us to set this over, or do you want to try to?
Your Honor, the state's understanding is that there was a prior conviction of 1599 back in 2013. On further review of the statute, it does appear to provide in subsection J2, quote, for purposes of determining whether a conviction is a first, second, or subsequent conviction in sentencing under this section. Only convictions occurring in the immediately preceding 5 years, including prior to prior convictions, determining the sentence to be imposed within the limits, provide for a first, second, or subsequent offender, whichever is applicable. So the state will respectfully defer to the court as to how it wishes to proceed under those circumstances.
Thank you. Tell me one more time when the prior was.
In accordance with my duty as an officer of the court, Your Honor, the state would proffer it to be from September of 2013.
All right. Did the officer already show up over here?
11 years ago. All right.
Or is he just on this call?
Does Mr. Malone have a valid license at this time, Mr. Cannell?
Yes, Your Honor. Yes.
All right. At this time, Mr. Malone, can you hear me still?
Yes, I can.
All right. For count one, transporting container, the charge for which you're convicted, your fine will be the maximum allowed by law of $200. Your court costs are $108, and your KBI lab fee will be $400. And of course, whatever you owe Mr. Cannell, that's private between you and him.
Yes,
But
no, That's understandable, Judge.
Okay, so what it looks like you're going to owe the court is $708. And there's no recommendation for jail time. You don't have any probation. I'm not going to suspend your license at this time because the charge was 11 years ago and you haven't had any since. But that's not to say if you have any more troubles, the next sentencing judge might see it a whole lot differently. How soon can you pay the $708? Do you need a little time?
Judge, we visited about, he can pay it before the end of the year.
So he's asking for about 90 days to pay.
Yes, Your Honor.
That will be the order of the court, 90 days to pay. And there is an online, or you can mail it, or you can walk it into the clerk's office. But Mr. Malone, if you don't get that paid, the Department of Revenue will probably suspend your license, and you'll probably get a collection agent after you, doing all the things collection agents do till they get their money. So keep that in mind.
Yeah.
All right. Anything further, Mr. Regier?
Not on this matter, Your Honor.
Very well. Anything further, Mr. Cannell?
No, Your Honor. Thank you for taking the time.
That's no problem. You're welcome, and you may go.
Thank you, Judge.
You're welcome. Mr. Jensen, do you have a plea?
Yes, Your Honor. Mr. Regier and I have visited on State versus Woods, which is case number 23 CR 336.
Mr. Regier, if you get another prosecutor to negotiate some of these, let me know. Because I'd like to put some of you in breakout rooms to attempt settlements if possible.
And Judge, I apologize for interrupting, but yes, I'm looking for a prosecutor I can talk with while you're doing these other things.
You have so many cases. Yes, if there's any way in the world we could get another prosecutor, I would be very grateful. Otherwise, we may be here till 5 o'clock. All right, Mr. Woods.
We got
Maybe 5
Woods.
o'clock tomorrow. Poor Joe. I should never try to touch it. All right, we are on the record in 2023.
Let me mute it.
Someone needs to mute. Yes, thank you. We are on the record in 2023 CR 336, State of Kansas versus Troy Scott.
Bottom right
Woods.
is a vibe.
Please announce appearances.
Jared Regier on behalf
No
of the
two ways
state.
about it.
Gail Jensen for Mr. Woods, who is present with me in my office and appearing on the right side of me by way of Zoom.
And how does he wish to proceed today?
Your Honor, it's my understanding, I visited with Mr. Regier last week. We will enter a no contest plea to an amended charge of disorderly conduct.
And remind me the statutory side of disorderly. Do you have that handy?
Your Honor, the state's understanding.
up,
pursuant to
counsel.
plea
My
negotiations that in
God.
exchange for a plea to count one, the state is prepared to amend
Have a Red Bull.
it to
Something.
disorderly conduct, specifically under KSA 21-6203 subsection A1.
Say 6203.
Yes, Your Honor.
I don't even know. I don't know what to say there.
Okay, disorderly conduct, and you said subsection Brawling and fighting, disturbing an assembly, or fighting words.
A1 would be the state's amendment,
Brawling,
unsuccessful entry of the plea, Your Honor. That does appear to be brawling or fighting pursuant to the same statute.
All right, thank you. All right, Mr. Woods, I understand the state has amended this charge to disorderly conduct to offer you a plea agreement to a Class C misdemeanor. Is that your plea agreement?
Yes, ma'am.
Then how do you plead to the amended charge of disorderly conduct, which is causing alarm, anger, or disturbance in others, or provoking an assault or breach of peace by brawling or fighting? It's alleged you did that in Butler County, Kansas on July 7th of 2023. How do you plead to that?
Guilty. No contest.
All right, by pleading no contest, you mean you don't want to admit it, but you don't want to deny it and take it to trial?
Yes, ma'am.
And you know, right now we're set for jury trial on battery. But if you continue your no contest plea, you will be found guilty if the state can provide a factual basis, and will proceed to sentencing. Is that what you want to do?
Yes, ma'am.
And you're giving up your right to trial. You'll be found not only guilty, but you won't be able to appeal that conviction. Do you understand that?
Yes.
And is anyone making you enter this plea today by any threats or promises?
No, ma'am.
All right, Mr. Regier, do you have the factual basis for disorderly conduct?
Yes, Your Honor. Pursuant to paragraphs 4 and 5 of the affidavit, it appears to refer to an incident that occurred on Thursday, July 7th, 2023. Law enforcement was dispatched to a specific address in Augusta, Butler County, Kansas. Were this case to proceed to trial, the state's evidence would show that the defendant, quote, punched the victim in the face twice before leaving at a particular residence.
All right. Were there
Behavior
any
in this case is
witnesses or
disgusting.
community that could have seen or heard this?
Your Honor, the state's evidence would show pursuant to paragraph 8 that that loud words were exchanged, and that and it was following that law enforcement was dispatched to the alleged premises.
All right. Well, it stands to common sense and common reasoning and knowledge that that would upset the neighbors. It certainly would upset the man punched. Who'd you say that was punched?
One moment, Your Honor.
Well, I don't necessarily need a name, but you're saying it was a neighbor?
The affidavit does appear to refer to a particular individual, and that paragraph 5 of the affidavit does appear to suggest that such an individual was a neighbor.
Okay.
It appears to.
All
Can you
right,
read?
and that happened, you said, in Augusta, July 7th of 23. I find that the defendant's no contest plea is freely and knowingly made, voluntarily entered into with a factual basis supplied by Mr. Regier. Therefore, I do find the defendant guilty of the amended charge, disorderly conduct. Recommendations for sentencing.
Yes, Your Honor. In this matter, the state is recommending court costs, which I believe would be $158 and a $300 fine. As the amendment does contemplate an amendment down to a Class C misdemeanor, the state is recommending a 30-day underlying sentence with 6 months of reporting probation, subject to all standard conditions, with special emphasis on no contact with the victim and $60 probation fee. I will, of course, defer to the court on the issue of repayment of the case.
Mr. Jensen, any recommendations?
Your Honor, Mr. Regier advised me of his recommendations at the time we were discussing this matter last week. So the only real one that I wonder if the court wants to do is require reporting for a 6-month period of time on a Class C misdemeanor to court services. But I'm
Oh, come on.
more than willing to leave it in the court's good discretion, Your Honor.
Speak up.
Let's see.
All I heard was diabetes.
Well, I thought Mr. Wood was familiar to me from other matters. Looking at his Odyssey record, he must be familiar to me because this case has been so ongoing and he's appeared so many times in this case. But it was amended down from a battery. It does sound like the prosecutor could have maintained that. One other question, Mr. Jensen, are you retained in this case?
I am.
Okay. All right, Mr. Woods, can you hear me?
Yes, ma'am.
Your fine will be $300. You will be assessed court costs of $158. And your attorney's fees are private between you and Mr. Jensen, so I will not address those. You are given a 30-day controlling sentence. I am going to grant you reporting probation because of the nature of this originally being a battery. I just want to make sure that you comply. Although the case does have, again, a little age to it, and I haven't had any more problems with you on bond, but I'm going to start you out on a 6-month reporting probation. That means you're going to have another $60 on your supervision fee. You're ordered to have no contact with this neighbor, and I didn't get his name, but now I think we do need to put it in the journal entry. What is your neighbor's name?
I don't know.
All right, Mr. Regier, do you have the name now? I'm sorry, I didn't get it earlier now.
One moment, Your Honor. Your Honor, the information under the endorsed witness section does refer to a specific individual by the name of John William Nice III.
All right. No contact with John William Nice III. Stay away from his home and his family. I mean, if you're neighbors, but you don't have to make a point of having contact with him or his family.
Dude literally hits his neighbor
You are to
twice.
call probation immediately
And his name
after
is
this
Knight.
hearing at 316-322-1553.
I can't make this shit up.
4153. And make sure you get a hold of them because you're the one on probation. You're the one that can get your probation revoked if you don't. So it's 316-322-4153. It looks to me like your amount owed comes to $518. Do you need some time to pay that? And if so, how much?
No, I don't need time.
Can you pay that today or?
Last name's Z.
I'm sorry?
Yes. Yes, I can.
All right. Well, I'm going to officially give you 30 days to pay. If you want to pay online, you'll have to wait till we get the journal entry, but you can always pay through the mail or in person at the courthouse there in El Dorado. Anything else, Mr. Regier, that we need to address on this case?
Your Honor, is besides the no contact order and the 6 months reporting probation and the standard 6-hour probation, is that reporting probation subject to all standard conditions as well?
Good point. Yes, all standard conditions will apply. Conditions.
Thank you, Your Honor.
All right. Mr. Jensen, anything further on this matter?
Not at this time. Thank you.
Thank you. You and your client are excused.
Good morning, Your Honor. I don't mean to interrupt. This is Richard Vargas. I'm here
Yes.
to interpret for a case.
Who do you have, Richard?
Alberto Sepulveda Figueroa.
And who is his attorney, Jen? Alberto Sepulpa. Is that a Mr. Jensen or Mr. Patterson case?
Yes, it is.
What is the defendant's first name? What's it under? Is it under the S's?
It's under the S.
Okay. All right. Can we get Mr. Jensen out of the breakout room? And now I see we've got someone in detention too. So,
Mr. Patterson is in the breakout room with Devin. Would you like me to interrupt?
yes, please, because they could be there a while.
In the meantime, I need a breakout room with with Kristen Huerta, who is under Lachelle Crenshaw. I know that was set up earlier, but I don't think Ms. Huerta realized that she needed to click on the join. So I'm not sure if that breakout room is still available, but if and when it is, if that could be set back up, and Kristen, if you could join the breakout room when the prompt comes up, please.
And if you
Jen,
could throw
can
us in
help
that
them?
breakout room, that'd be great. I know my chat would
Click
like
on
to
that
see that.
invitation when it comes up, ladies. Looks like they did.
Pardon me, Judge.
Yes.
I had a message to return to the meeting.
Yes, interpreter Richard Vargas is here, wondering if we can go ahead and take up Alberto Zapaleta Figaro.
Fantastic gringo.
Judge, have a brief breakout room with Devin, and then, yes, I'll be ready on that really quick.
Is the defendant here?
He should be in jail.
Is that?
Yes,
you?
Your Honor. He's
Is-
the one on the screen, Your Honor.
Okay, there we go. Yes, all right. So Mr. Patterson needs a breakout room with Mr. Canfield, and then you need one with your client?
It'd be very short, yeah.
Okay, so Jen, if you'll take care of that, I'll go ahead and call another case.
Oh, we got Mr. Canfield, the spare gear. Life is good.
We will be taking up Mr. Chandler on the record in 2023 CR 447, State of Kansas versus Bryce Richard Chandler. Please announce appearances.
Jared Regier on behalf of the state.
Did I lose Mr. Watts? James Watts? There you are. Oh, you're on the phone?
Hang on one second. Good morning, Your Honor.
Okay, we have. Do you need me to come back to your case, Mr. Watts?
Your Honor, I'm actually speaking with my client right now. I think we're about to resolve this matter, at least I hope so.
I'll come back
Perhaps
to
I can
you.
come back in a moment.
Sure, I can do that. How about Matt Levitt and Della Schmidt? How about Michael Martinez and Mr. O'Hara?
Yes, Your Honor.
Will be on the record in 2024 CR 95, State of Kansas versus Michael John Martinez. Please announce appearances.
Jared Regier on behalf of the state.
Chris O'Hara appears on behalf of Michael Martinez.
And where's Michael Martinez?
He's on video too. He's in our office.
He's in your office? Oh, there he is. Okay. And how does he wish to proceed, Mr. O'Hara?
Your Honor, we filed like 4 motions, and I spoke, I guess I contacted Ms. Norris. I think he's got a jury trial coming up Wednesday. We were asking to, I guess, continue the jury trial, then set it for a motions hearing.
Are we talking suppression and other issues?
Yes, it's a motion, there's a motion to suppress, a motion dismissed based on the Second Amendment for the firearm and a self-defense immunity.
Well, he has a lot of cases, battery of a law enforcement officer, another officer battered, interference with law enforcement, disorderly conduct, possession of a firearm under the DUI. Someone mute, please.
I have a copy.
Someone mute. We have battery of a civilian apparently, pedestrian under the influence of alcohol or drugs. And you said that is Miss Norris's case.
Which is number one.
Your Honor, I think also, if Your Honor might recall, there was some subpoenas that went out for business records. And my understanding was that Miss Norris she got some of them back, but she was waiting on some others to return as well from the hospital record.
What do you mean?
Okay, now the person's whispering, but we still hear you. Jen, can you mute whoever that is in the middle of this hearing with their private conversations? Well, this case is going to probably be close to a year old by the next trial date if you need one.
Andrew.
But what's the state's position, Mr. Regier? I understand Miss Norris is in agreement with this continuance?
Your Honor, I have had the opportunity to communicate with my colleague regarding this matter. Under these particular circumstances, the state does not object to the matter being set over.
All right, well, we may need to make that a prime if it, depending on the outcome of those motions hearing. So is this a joint request to continue it or just one party?
The defense is requesting it. I don't know what the state's position is.
Okay, well, you said that she didn't have all of her subpoena information, so, but this, I'll show the time to the defendant, and this will have to be set for February 3rd, 9 a.m. pretrial. That will be by Zoom. And then jury trial will be February 5th and 6th live in person at the courthouse. Anything further other than to continue the defendant on the bond with all existing conditions and added conditions that he reappear at the additional times given?
Your Honor, the motions hearing is.
Oh,
that-
we need to get dates for those. How much time do you think those are going to take?
I would say probably 2 hours, maybe 3.
All right, can we, Jen, reserve 3 hours on a subsequent traffic afternoon docket, trial docket?
Yes, one moment, Judge.
Okay.
You want it on the bench trial docket?
I think so, yeah. And it doesn't have to be right away because our trial's not until February. Although that'll be here before we know it.
December 11th.
Counsel, are you available December 11th at 1:30?
Just a moment, Your Honor.
Very well.
Yes.
Mr. Regier, I trust that'll work for the state.
No objection to the December 11th, 1:30 setting, Your Honor.
All right, Mr. Martinez, I will continue the existing bond, all additional or all existing conditions plus the added condition to reappear for motions hearings December 11th at 1:30.
Your Honor,
Yes,
there was one other thing. We had filed a motion to modify bond conditions to have Mr. Martinez's scram bracelet removed. And I think we didn't actually have a hearing date on it. I think you were trying to see if me and Ms. Norris could work it out. Ms. Norris and I could work it out. She had said that she, if he had no violations by the time he appeared at this hearing, that she would join in asking that the scram bracelet be removed. If the court would be inclined, if the court would be willing to do that, if I could contact Ms. Norris and we could present an agreed upon order.
I am not inclined to do that considering he has counts of battery against several officers or a couple officers and another person. He's got alcohol allegations. So I'm going to leave that on in light of the charges and the potential threat to the community. Also, if he gets under the influence of alcohol, he may just forget or decide not to come back. So I'm going
Your
to.
Honor, he's not been in any other trouble before. He has no prior criminal history and he's had the device on since March 4th. And he just recently graduated in May, college from Wichita State and is applying to go to medical school. He hasn't had any prior incidents at all and has had no violations since he's been on scram.
What's he going to do between now and when the medical school session starts? Is he working? Is he just hanging around? What's he doing?
I need to volunteer to free clinic.
I can't hear you.
He volunteers at a clinic.
A medical clinic
Yeah,
It's a medical clinic, yes.
in Wichita?
no, it's in Orange, California. I need to go back.
Oh, you're from California?
I had to quit.
He had to quit. He was doing that and he had to quit.
Councilor Walker, the people.
Good morning, Your Honor. Sam Bernstein here on behalf, not exactly with Mr. Bloom.
All right. We've had numerous discussions regarding the defendant's participation, just so that the record is clear. The defendant left the courtroom during the course, or at the very beginning, at least I think at the beginning portion of the people's closing argument. Upon his leaving and reviewing some case law at that point, we adjourned it to the continuation of the trial to today. Looking at additional case law without a great deal on point, and I don't have that. Yes. We had started out with, I believe it's the Swan case, People versus Swan. That's at 394-451, which we knew about last week, to try to deal with Mr. Bloom's absence from the proceeding. This morning, I had told counsel that the court additionally found the case of People versus Palmerton. That's at 200 Mishap 302, the 1993 case. And the long and short of it is that the defendant, to have a valid waiver of his right to be present at trial, that has to be established on the record. My understanding is that the defendant does not wish to come out. He is up in the court's lockup, but does not wish to come out and be present for these proceedings. Is that correct, Mr. Bernstein?
That is correct, Your Honor. I have spoken with him, expressly relayed that he has a right to be at the trial proceedings. Mr. Bloom states that he does understand that and he wishes to waive that right and have the closing argument in his absence.
All right, very good. And you're satisfied that he understands and is knowingly waiving his right to be present during the trial?
I am, Your Honor. Today was not the first time that I spoke about it, and I do think that he understands that he has the right to be here and wishes to waive that.
Copy, try me in absentia, and you're not going to prove anything.
Bloom is up here because Mr. Bernstein has talked to him. We could put on at least testimony of the officer or one of the transport officers to indicate that his understanding is that Mr. Bloom does not want to be present. Does either party think that is necessary given the representations of Mr. Bernstein?
Sure, I have absolutely no reason to doubt Mr. Bernstein. The only concern that people brought forward to the court was if there is a conviction and there's an appeal of that conviction, if Mr. Bloom may make representation that is not what he told Mr. Bernstein, I would request that the court make a very short inquiry of one of the transport officers that it's their understanding as well, if the court would be so inclined.
That may make sense. So if we could have, was it Officer White? Was it?
I do think Corrections Officer White is up.
Yes, he could come out.
Sorry, ladies, I know you're hoping for Mr. Allen. But there he is. You know, it'd be great is if the Sallyport stash guy popped in here for a cameo. That would make this stream complete.
Deputy White, if you could come to the podium, please. Mr. Allen, if
A
you could
little
swear
crossover, you know?
All right, and you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State and spell your first and last name for the record, please.
Matthew White, Matthew
All right. And you're employed with the Washington County Sheriff's Office
Yes,
and in the transport division?
that's correct.
All right. And you were in part responsible to transport Mr. Bloom to these proceedings today?
Yes,
And he was brought up from the jail to the lockup off of the courtroom. Is that correct?
Yes.
All right. During the course of that, and in terms of getting him ready for trial, did Mr. Bloom make any representation to you or in any way indicate to you that he did not wish to participate in these proceedings?
Yes, he did. He just said that he felt like his trial was over and he didn't need to be present.
All right. And is it your understanding that he does not wish, based upon those conversations and his actions, is it your understanding that he does not wish to come out and participate in these proceedings?
Yes.
All right. Any questions from the people?
Your Honor, people are satisfied.
Any questions from the defense?
No, Your Honor.
All right, thank you, Corporal. All right. I think we dealt with that matter. There is then the issue of an instruction to the jury. During a break while we had an opportunity to speak, I had an opportunity to speak to counsel. I asked them to draft something that they would believe would be sufficient to instruction to give to the jury. They have drafted, and we have a copy of the instruction that I believe the parties wish read to the jury. Mr. Bernstein brought up the point that not to necessarily read that, or it could be read with my final instructions, but that the real issue was that there had to be some explanation or something to the jury once they came into the courtroom. And so I had indicated, if there's no objection, that I would read that. Excuse me one moment. That I would read that once the jury enters the room. The instruction that counsel has presented is that during the course of this trial, the defendant has chose to no longer be present for the proceedings. His absence should in no way impact your deliberations and verdict. Is that a correct understanding of?
Yes, Your Honor.
It is, Your Honor.
All right, very
Does the
good.
court consider giving it to the jury when they come in, and then also in the final instructions?
I would consider that. I certainly was going to give it on Mr. Bernstein's request once they came in to explain the defendant not being present. If you wish me to give that during the closing instructions, I could do that also.
If the court wouldn't mind, I would appreciate that, just so it's very clear that this is your new instruction. And when the court instructs the jury to take the jury instructions as a whole, I think it would be helpful just to have that included as well, that is a piece of this trial.
All right.
I don't mind. It's belt and suspenders, so.
Haven't
I
heard
just
that.
want to say that.
Haven't heard that in a while, but yes, okay. Just want to make sure I have 11. I think then what I would do is, since Mr. Bloom did not testify, I would insert the reading of that instruction around that same point as the reading of 3.3, the defendant not testifying. I think, yeah.
Sequentially, that seems to make sense. Thank you, Your Honor.
All right, very good. Are we ready for the jury?
El Estado recomienda $100 de multa con 4 meses de sentencia suspendida, con tal que no se meten problemas, y 6 meses de libertad condicional sin su.
Did you need some
I
time?
was gonna just ask for just a couple of moments, but if that's okay with the court.
Yeah, no stop. Yeah, that's fine.
Thank you, Your Honor.
And why don't we do this? Court is standing in recess for about 5 minutes or so. All right, thank you.
That is so ordered.
Esa va a ser la orden.
And Judge, we'd ask court to adopt the recommendations. I am court appointed in this case.
All right. Mr. Sepulveda, why are you still in custody?
We'd ask the court to
Señor Sepúlveda, ¿por qué todavía sigue
call the
en custodia?
Huerta
No lo sé.
while we're on break in
No
Simpson's
sé
room.
por qué todavía siguen en custodia.
I don't know. I'm not sure why I'm still here.
Well, why did you not make a bond?
¿Por qué no pagó una fianza?
Traté de pagarla, pero como no soy residente de Kansas, no me pudieron fiar.
I tried to pay it, but since I'm not a Kansas resident, they didn't allow me to pay it.
Mr. Patterson, do you have any idea if that's right, that he couldn't find a bondsman?
That's what I understand, Judge, and that he has now been in custody since June 11.
Eso es correcto, señor Patterson. Sí, su señoría no pudo encontrar una fianza. Ya estaba en custodia desde el 11 de junio.
What kind of work do you do, Mr. Sepulveda?
¿Qué tipo de trabajo hace, señor Sepúlveda?
Yo soy mecánico de carros.
I'm a mechanic for cars.
Will you have a job to go to as soon as you get out?
En cuanto salga, ¿sí va a poder volver a trabajar?
Llevo 5 meses aquí, yo espero tener trabajo tan pronto salga, pero no estoy seguro.
I've been here for 5 months. I hope I can get back to work.
Counsel, he's almost, if I go with this 120 days, he's almost, if not, flattened his time. Or are you contemplating that in your plea agreement?
That was somewhat discussed and contemplated, Judge.
Yes, Judge.
Si voy hasta como está en este acuerdo, ya iría casi su tiempo, los 120 días. Sí, señoría, eso ha sido contemplado.
And I would add that the time served was primarily on the criminal case, which is being dismissed.
Okay.
El tiempo servido primeramente en el caso criminal que les está siendo desestimado.
Where are you from, sir?
¿De dónde es usted, señor?
Yo vengo de Orlando, Florida, pero resido aquí en Kansas en estos momentos.
I came from Orlando, Florida, but I've been living in Kansas.
Ya llevo casi un año viviendo aquí en Kansas.
I've been living in Kansas for about a year.
How long did you live in Florida?
¿Por cuánto tiempo vivió en Florida?
Viví 14 años en Florida.
For 14 years in Florida.
And what brought you to Kansas?
¿Y qué es lo que lo trajo a Kansas?
El trabajo.
Work.
As a mechanic.
Como mecánico.
Es mecánico.
And what company were you working for?
¿Y para qué compañía estaba trabajando?
Yo estaba trabajando para la compañía Mid Kansas Ocean.
¿Cómo dijo?
Mid Kansas Ocean en Wichita.
Mid Kansas in Wichita.
Mid Kansas Auto Ocean.
Oh, okay. I think it's Mid Kansas Auto Collision in Wichita.
Auto Ocean. No.
Auto Collision.
When you get out of jail, are you going back to whoever this victim of the domestic violence was?
Cuando salga de la cárcel, ¿va a volver con la víctima de este supuesto caso de violencia doméstica?
No tengo ni idea, no tengo idea de ni dónde está, ni quiero volver a saber de esa persona.
No, I'm not sure where they might be at, and I don't really want anything to do with that person.
So you don't know where you're going to live when you get out.
Pero entonces no sabe dónde va a vivir.
Sí, tengo rentado un apartamento. No tengo la dirección aquí conmigo, pero la tengo en el cuarto.
Yes, I do have an apartment rented.
And you've kept the rent paid on it?
¿Y si ha estado pagando la renta?
Sí, mi familia ha estado pendiente a eso.
Yes, my family has been helping out with that.
How long will it take you to pay $458 to the court?
¿Cuánto tiempo le tomaría pagar esos $458 a la corte por los costos?
$450 a la corte, bueno, antes de que se acabe el año, diría.
450 probably before the end of the year.
Well, how much have you been paying each month on this rent?
¿Cuánto es su renta mensual?
Son $250 nada más.
It's only $250.
Okay. All right, here's what I'm gonna do with your sentence, sir. Your fine is $100. Your sentence will be 6 months in jail, but I will give you credit for time served on this case.
Entonces, eso es lo que voy a hacer en tu caso. Le voy a dar crédito por tiempo servido en este caso.
Then I'm ordering you to pay 108 in court costs and 250 of your court-appointed attorney fees.
Va a pagar $108 de costos de la corte y 250 por los costos de tu abogado.
I will grant you 6 months 6 months reporting probation
6 meses de libertad condicional reportada.
for the rest of your sentence, meaning you will not have to serve it as long as you do well on probation.
Y no te va a tener que hacer otro más tiempo de cárcel si todo le va bien en libertad condicional.
You will need to report as soon as you get out of jail to probation at 316-322-4153.
I'm sorry, can you repeat that again, Your Honor?
Yes, 316-322-4153.
En cuanto sea liberado, tiene que llamar al oficial de libertad condicional. El número de teléfono es 316-322-4153.
They will go over with you the conditions of your probation, and I will give you 90 days to pay your fines and costs.
Entonces, va a tener que seguir las condiciones de ellos y pagar los costos de la corte.
If, when you get this paid off, I will consider an early termination of your probation.
Si paga, en cuanto pague esto de libertad condicional, puedo considerar de terminar su libertad condicional antes.
Because I am putting you on reporting probation, there will be another $60 supervision fee.
Y va a haber otros costos de $60 de supervisión.
The other case, the domestic battery, is again dismissed with prejudice per plea agreement. Counsel, is there anything else we need to address on this case?
No, Your Honor.
No, Your Honor.
All right, thank you. You are
gracias.
excused, sir. And before I let him go, the file is showing his spelling as SEPULUEDA. Is that the correct spelling, or is there a V in there?
It's a fee in there.
People versus Jeffrey Blow. And we are ready to proceed now.
Yes, Your Honor, thank you.
Yes, Your Honor.
All right. Bring it in. Ms. Lundy, I know I had indicated you couldn't turn the podium. I know you prefer that. If you want to turn it now, that's fine with me. It's up to you. I just did not want your back to Mr. Blow.
I understand the security risks the court finds inherent in doing that, and I will not turn it.
Okay.
I'm still here, Judge, so.
I'm less concerned about that.
Then you can figure out who I care about, Sam. You know, I don't mean that.
Juror. May be seated. Your Honor, the jury is present.
Thank you. Good morning, ladies and gentlemen of the jury. Initially, what I would do is I would give you an interim instruction and just tell you that during the course of this trial, the defendant has chosen to no longer be present for these proceedings. I would admonish you and ask you to remember that his absence should in no way impact your deliberations or your verdict. All right. Ms. Lundy, we're at the point of closing arguments. And I believe when we stopped, you were in the middle. However, you may begin again with your closing argument.
Thank you, Your Honor. Your Honor, with the court's indulgence, at this time, I'm going to end my closing argument. I trust that the jury remembers it and remembers what I had to say, and I don't see the point in sort of rehashing all of it. They've been paying diligent attention. If that's okay, if that pleases the court and defense counsel.
That's fine with, that is fine with the court.
Thank you. I do reserve any further argument for rebuttal closing.
Thank you.
Thank you.
Mr. Bernstein, closing argument.
Thank you, everyone, for coming back. That day, Rocky saw Jeff in the jail and found Jeff to be yelling, saying he didn't trust him. And we've been through this trial now together, and we've seen how that has all played out. And my question for you guys is, where's the beef? Really, where is the beef? There was a question posed to Rocky. Did he have any reason not to trust you? Rocky said, not at all. There were no problems between Rocky and Jeff. There was no history between Rocky and Jeff. I don't mean to minimize any impact from this on Rocky. The prosecutor in her closing did a good job of talking about the emotional connections that we have with nurses. I get it. My wife's a nurse. My grandma was a nurse. That's not exactly the situation here, though. This wasn't the cozy urgent care. Rocky said when he met Jeff, Jeff is just screaming uncontrollably. He's in fear for his life. He doesn't trust him. There needs to be an officer to calm him down. It's just not a normal situation. And I can understand how Rocky feels the way that he does. After he leaves there at first, there's no problems. Nothing hurts. He walks away. Then he starts talking to people. He starts retelling the story. There's his email. There's his medical records. The story changes. It does. The situation that we do have here is that there are two officers standing right there. Both officers said that they did not see Rocky hit that door. They did not see Rocky hit that door. They did not see Jeff grab Rocky. We watched a video twice. That video showed nothing at all. Of course, there was one major way that we could have resolved this. There was a camera pointed right at Jeff's cell, and no one talked about doing anything to see if that camera captured it. Instead, we were shown a video that showed nothing. Come back to my original question, guys. The original question I posed, where is the beef? And I don't mean motive, okay? This isn't an Agatha Christie whodunit novel, right? But like, why? The question isn't whether Jeff pulled his arm back. The question is, why did he do it? If there is no intent to commit a battery, then there is no battery. Without intent to commit a battery, there is no crime. Without a beef here, there is no battery. We asked you here for your help, and I get how we got to this point. Jeff is not going to get the benefit of the doubt. He was in jail. That's fine. I get it. A lot of what's been talked about in this trial has always come with an explanation. It's been glossed over, minimized, explained away as if these things don't matter. Does it not matter that Officer Navin testified that he was standing right there and didn't see that happen? That he didn't see Rocky hit the door? Does it not matter that Officer Tweedell was standing right there as well and did not see Rocky hit the door? We saw a video twice that didn't even show anything. We didn't hear about any efforts of anyone trying to get the other video. I mean, does it not matter that Jeff is having an emergency? Does it not matter that there's a perfectly reasonable explanation for this? That's not a crime. The guy's freaking out and doesn't want Rocky to touch him. He's talking about he's in fear for his life. Jeff doesn't want to hurt the guy. He has no beef with the guy. He has no beef with Rocky. I say that these things do matter. Jeff does deserve the benefit of the doubt. And legally speaking, he gets that benefit of the doubt unless you are really shown something otherwise. But we have not seen that here. Absolutely not. You are the only people that can help Jeff. And we have asked you here to listen, and we are asking you now for that help.
Thank you, Mr. Bernstein. Rebuttal.
Defense counsel says you are the only people here who can help Jeff. But that's not true. Because there were plenty of people who tried to help Jeff on the day that this happened. There were guards to get him the medical attention he wanted. A second guard brought in to make sure nothing happened. And Rocky brought in to assess his vitals and see if he needed emergency medical treatment. All three of those people tried to help Jeff on that day. All three of those people tried to get the defendant the help he needed to keep him safe, which is what I talked about last week. Safety is the priority of the three men that you heard from. That's their job. Defense counsel's asking, does it not matter that this guy is freaking out? Look at the law. Look at the jury instructions. Listen to the ones that you're about to hear and consider. Does the motive matter? No. And that his intent can come from all of the surrounding circumstances. And what does he do with that blood pressure cuff after he pulls it into that cell? Waves it around like a lasso. It's a game. It's a game for the defendant. Mr. Burnside says this video shows nothing at all. Except that that's not the case, because the video shows you exactly what Officer Navin testified to, exactly what Officer Tweedale testified to, and it shows you Tweedale standing there, frankly, making a better door than a window, blocking the view of the camera. Those men easily could have come up here and said, yes, I saw the whole thing. I saw Rocky get slammed. But they don't, because that's not what happened. They're focused on Jeff. They're focused on the defendant. They're focused on this person who's demanding medical attention, and they're so concerned they do it through the food slot. Rocky told you how he had his arm, and he showed you, demonstrating he had his arm all the way out, bent all the way down. This isn't like somebody got grabbed by the hand and pulled in. This is somebody who's already extremely close to that door. The defendant's the only person that day who made a choice to compromise the safety of another human being.
People are asking you to hold him accountable and convict him.
Thank you. Members of the jury, the evidence and arguments in this case are now finished, and I will now instruct you on the law. That is, I will explain to you the law that applies to this case. Remember, you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy or bias or prejudice influence your decision. You must avoid reaching conclusions that had not been, you must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about the case individually, but you should do so only after listening and considering the opinions of the other jurors, who may have different backgrounds and perspectives than yours. As jurors, you must decide what the facts of this case are. This is your job and nobody else's. You must think about all of the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each witness has said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, you are to follow what I say. At various times, I have given you some instructions about the law. You must take all of my instructions together as they are the law that you must follow. You should not pay attention to some instructions and ignore others. To sum up, it is your job to decide what the facts of this case are. Apply the law as I give it to you, and in that way decide this case. A person accused of a crime is presumed to be innocent. This means you start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty, unless and until you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. During the course of this trial, the defendant chose to no longer be present for the proceedings. His absence should in no way impact your deliberations and verdict. Every defendant has an absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must affect your verdict. It must not affect your verdict in any way. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses and anything else, and the exhibits that I've admitted into evidence, and anything else I may have told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe to you some things that are not evidence. The fact the defendant is charged with a crime and is on trial is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things the lawyers say that is supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses and my questions to the witnesses are also not evidence. You should only consider these questions as they give meaning to the witness's answer. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to the case. However, if I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe I have an opinion about how you should decide this case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case solely from the evidence. Your decision should be based on all of the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but should not use any personal knowledge you may have about a place, person, or event. To repeat once more, you must decide this case based only on the evidence admitted during this trial. As I have said before, it is your job to decide what the facts of this case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you have based upon the witness's disability, race, national origin, ethnicity, gender identity, sexual orientation, religion, age, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and reflect carefully about the evidence. There are no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or other personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not fully agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose to not accept anything that witness has said. On the other hand, if you think the witness lied about some things, but told the truth about others, you may simply accept the part you think is true and ignore the rest. Prosecutor in this case must also prove beyond a reasonable doubt that the crime occurred on or about May 30th, 2023 within Washtenaw County. Possible penalty in this case should not influence your decision. If the defendant is found guilty, it is my duty as the judge to fix any penalty within the limits as provided by law. When you go to the jury room to deliberate, you may of course take your jury books with my full instructions. You also will have contained within that jury book at least one of the exhibits that have been admitted into the trial. As to the video, if you wish that was admitted, if you wish to see that, then you just need to request it. As I've indicated, when you go to the jury room, you will be given a written copy of the instructions that you have just heard throughout this trial. And as you discuss the case, you should think about all of my instructions together, as they are the law that you are to follow. The prosecution has introduced evidence of a statement it claims the defendant made. Before you consider such an out-of-court statement against the defendant, you must find that the defendant actually made the statement as it was given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this, you should think about how and when the statement was made and about all of the other evidence in the case. You may consider the statement in deciding the facts of this case. And in facts can be proved by direct evidence from a witness or exhibit. Direct evidence is evidence about what we actually see and hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all of the evidence that you believe. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find the person guilty of a crime. Prosecutor does not have to prove the defendant had a reason to commit the alleged crime. He only has to show that the defendant actually committed the crime and that he meant to do so. Defendant's intent may be proved by what he said, how he said it, and by any other facts and circumstance in evidence. Ladies and gentlemen, you have heard testimony from witnesses that are correctional officers. That testimony is to be judged by the same standard you use to evaluate the testimony of any other witness. The defendant in this case is charged with the crime of assault and/or assault and battery. The prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant committed a battery upon Rocky Isley. A battery is a forceful, violent, or offensive touching of a person or something closely connected with the person of another. The touching must have been intended by the defendant, that is not accidental, and it must have been against Rocky Isley's will. It does not matter whether or not the touching caused an injury. Second, that the defendant intended either to commit a battery upon Rocky Isley or to make Rocky Isley reasonably fear an immediate battery.
And there's your problem. I think he did, but I don't think the state has proven that beyond a reasonable doubt. I think he absolutely intended to do that, but just the way the facts shook out in this case, it's very hard to prove beyond a reasonable doubt that that was his intent. When you have a perfectly good alternate theory that he was like scared and pulled his arm back.
As used in these instructions, the words force or violence means the use of physical force against another person so as to harm or embarrass them. For a battery to occur, the touching must have been intended by the defendant. That is not accidental, and it must have been against the will of Rocky Isley. Does not matter, as I've indicated, whether or not the touching caused an injury. Ladies and gentlemen, when you go to the jury room, you will and have been provided a copy of my final instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried on in a business-like way and that everybody has a fair chance to be heard. During the deliberations, make sure to turn off any cell phone.
Okay, so I'm gonna flip over here in a second, but I sort of given you what I think. I think he is guilty as a matter of fact. I don't think he will be found guilty as a matter of law. I think Miss Landy did a great job with rough facts for a prosecutor. I don't think the prosecution's main witness, namely the nurse, was overwhelmingly good. Not terrible, but not good enough to carry the day. And if I had to guess, we're going to see a not guilty on this thing. Although in my heart of hearts, I think he absolutely was playing a game and intended to hurt this guy. That's what I think is going to happen. I have no idea. But that's what I get from watching this trial. The problem was we had a video of it. It showed nothing. We had witnesses outside of him who said, I didn't see him move or anything. And he himself said he didn't get a hold of my hand. He just pulled his back. Well, they're connected because he's trying to hold his arm to give him blood pressure. So it's clear in context that you can injure somebody that way, but it's not clear to prove intent. He's got other charges he's going to get rung up on. This one was difficult, but the prosecutor did a damn fine job. Nothing sleazy. She's right. They didn't have people change testimony or lean to and sleaze him that way. They really didn't. The defense attorney did a great job. They both made damn close to the arguments I would have made if I represented those parties. They didn't beat it to death. They said what they had to say and shut up. They were consummate professionals. Judge Simpson did a nice job. Defense did a nice job. Prosecution did a nice job. The facts of this case are really hard because of that intent element and the burden. That is it. Now, I think the state proved it enough that, yeah, I mean, if you get 12 people are just like, yeah, we see it. I think it's perfectly justified to convict him on this. I just don't think you will. I think at least some of those people are going to be like, yeah, he bothers me, but I can't say beyond a reasonable doubt that he meant to hurt the guy. And that's enough. That's how these things go. So let's go over and check out the other situation. I think they'll deliberate for a while because there's some issues to discuss. But let's go over here.
No, I'm on Michelle Turner.
Okay,
I think it was Shannon first and then Richard took it.
all right. I just noted Shannon's name was still in the file jacket. Sorry.
No,
I
that's
think
me.
that's what it is. Well, let's take up our Sully Ibarra Morales. We're on the record in 2023 TR 879, State of Kansas versus Araceli Ibarra Morales. Please announce appearances.
Gotta say, Kansas Superior Advisor, Assistant County Attorney Paul Dean.
Richard Paul on behalf of Miss Ibarra Morales. Would the court please inquire?
Miss Ibarra Morales, are you here? If you are, you need to speak up so we don't think you're failing to appear and give you a warrant. Jen, did you? Well, who's handling my Greenwood County? Missy, are you on here somewhere?
Yes, Judge, I'm here and I'm handling.
Oh, I'm so sorry. So Missy, what are we doing about our Sully Morales? Has she shown up?
I do not see her on here. There are two people at the courthouse, but I don't think she's one of them.
Give me just a minute so I can pull this door shut.
I would look
There's
awesome.
2 people at the courthouse. That's right outside.
Can you unzip the front of it and show your chest?
Commission meeting. Because I think Miss Turner and Mr. Liner are at the courthouse,
And those are both mine.
but I don't think Morales is.
No, and I don't see her on here.
Your Honor, Miss Morales is not here.
All right, finding that the defendant fails to appear, recommendations from the state.
I'd request a bench warrant, given the fact that this was set for trial. I'd ask that have no bond authorized until she sees you,
She's
Your Honor.
here. All right, Mr. Paul, your response?
Judge, I would ask for a continuance on this matter. I know Miss Ibarra, I think recently was just let out of Finney County Jail, so.
Well, I appreciate that request, but it will be not denied. The bond forfeiture will issue with the bench warrant and a no bond hold. We will now be on the record in 2023 TR 807, State of Kansas versus Michelle Lee Turner. Please announce appearances.
State of Kansas Superior Advisor, Assistant County Attorney Paul Dean.
Richard Paul on behalf of Michelle Turner, who appears at the Greenwood County Courthouse.
And how does Ms. Turner want to proceed today, as we are set for jury trial on the one count of driving under the influence of alcohol or drugs?
Judge, after speaking with Mr. Dean, we have agreed to move this to the next jury trial date, Judge.
There's no way we can resolve this, folks. This happened allegedly July 30th, 2023. And the next jury trial date's not till February 25.
Your Honor, it's my understanding she wants to have a jury trial on this matter, and I'm not willing to dismiss the DUI.
I understand that. Well, she,
Filed it.
her case, well, Mr. Wallace's goes back to 23 as well.
And Judge, I know you have some really old Butler County dates that are probably going to be kicking us off anyway.
Well, maybe not, because we'll just take a look. Okay, folks, I'm gonna leave them both set. They have to just take a close look. Ms. Turner, I'm going to order that you be back here and ready for jury trial Wednesday, live in person, unless you're told otherwise. So you make sure counsel knows how to reach you.
She does.
I do.
All right.
All right,
Thank you.
you may go, Ms. Turner.
Thank you.
And then that leaves Ziner on the
Judge.
record in 2024, TR 63, State of Kansas versus Lamont. William Ziner, please announce appearances.
State of Kansas appears by and through Assistant County Attorney Plea Dean.
Richard Paul on behalf of Lamont Ziner, who appears in person at the Greenwood County Courthouse. Judge, we're still set for jury trial.
On a driving while suspended?
It's what Mr. Ziner how he wants to proceed, Judge.
Okay, so Mr. Ziner is maintaining that he was not driving while his license was suspended. Mr. Dean, are you maintaining the position that his records show he was?
Yes. I'm maintaining that this might be one of the shorter jury trials we've ever participated in, but such as it is, Your Honor.
Wait a minute. Lamont, don't say anything. Do you and I need to talk?
Yeah.
Zip it.
Okay. Put me in a break room, Judge.
Put them in a breakout room.
Thank you.
Who's doing that, Missy or Jim?
Shut your
I
pile.
am. I'll get them put in there.
Okay, thank you, Jim.
Your Honor, this is John Stang. I have a 10:30 in Sedgwick County. It shouldn't take that long. I'm here
Okay.
with Mr. Moose. Can we put me at the end of the docket, please?
Yes, we can do
I'll
that.
leave him online.
All right, thank you. And Mr., is it Beal or Bill? Bill, isn't it? Terry Bell? Terry
It's
Beal?
Bell.
Bill. Okay, let's take up your client.
It's Devin Foster. He's on the iPhone in the middle.
Okay.
I think in the middle of your screen. And it's 23 TR 300112.
We are on the record in 2023 TR 300112, State of Kansas versus Devin J. Foster. Please announce appearances.
Jared Regier on behalf of the state.
Devin Foster appears via Zoom with his attorney Terry Bell, who appears via Zoom in a different location.
And is there any chance we can resolve this short of jury trial, Mr. Bell?
I have emailed, this is Mr. Sweeney's case, and I had emailed him and I have not got a response about sentencing recommendations on the DUI. Last time we were set, I had told the court I had previously had trial scheduled for the 2nd and the 3rd, and I'm not available, and the court still wanted me to leave it on the docket to see where we're at, and I still have not gotten a hold of Mr. Sweeney. I emailed him this morning as well and asked him, I was on Zoom, and if he had sentence recommendations. I haven't received anything. I emailed him in September 16th before I went on vacation last week and haven't gotten a response either. So I'm requesting I can be able to continue this.
I'm requesting the county attorney get Mr. Sweeney in here, or someone that can resolve or at least negotiate this case in that direction.
Your Honor.
Mr. Regier?
At this point, I do not have any knowledge as to Mr. Sweeney's availability at this time. What I can tell the court is For purposes of reaching a resolution, in this particular instance, the state would be prepared to recommend minimums insofar as the fine is concerned for a Class A DUI, which does appear to be how this case is charged.
Why don't you and Mr. Bell go in a breakout room and talk about that?
Very good, Your Honor.
Jen, if you'd put them in a breakout room, please. Okay, Mr. Paul, we can go back on the record.
No, not yet, Judge.
Oh, he's not back? Oh, you need to talk to somebody?
Yep.
Oh, Mr. Dean? Mr. Dean and Mr. Paul, if you could put them in a breakout room, Missy. And somebody put Mr. Bell and Mr. Regier and Mr. Canfield. Can you do Mr. Andrews or Mr. Mr. Levitt, weren't you going to another court?
No, Your Honor, I don't have another court until 11.
Okay, well, let's
I'm in
get you
Baldwin
on.
County via Zoom then.
That was Mr. Stang, Your Honor. That was.
Judge, if I may,
Yes.
my understanding was that Mr. Regier had worked out all of these cases on the docket, so I have only spoken with Mr. Patterson about these cases. I do not know what Jared has done on the others.
And Judge, my announcement actually pertains to Miss Pierce, who I've worked with from the start, who I spoke with last week. I don't know if Mr. Regier or Mr. Canfield have notes regarding our communication, because I do not see Miss Pierce on this.
Well, if I'm knowing Miss Pierce, she left arrangements, but I really need to get these matters resolved. So, Mr. Canfield, do you have the Della Schmidt case?
If it's not a Mr. Patterson case, I have not looked at it, but I assume that Jared has reviewed any communications from Ms. Pierce.
I can wait until he's back from the breakout room, Judge.
All right, thank you. Mr. Dean, are we ready on the Greenwood County case?
I'm sorry, can I get a breakout room real fast? Huerta.
Yes, Your Honor. I'm sending out I've just sent a message to Richard.
All right. Jen, would you please put Ms. Huerta and Josh Andrews in a breakout room?
Okay, and who was the Greenwood County you needed in a breakout room?
The Greenwood County Courthouse, please.
Okay, Greenwood County Courthouse and Mr. Paul?
Yes.
Okay.
1 minute.
Mr. Dean,
Yes, Your Honor.
did you have a comment?
Oh, no, I just said that I sent Richard a text directly. We were waiting on that breakout room, and so I just responded to him via text, and I assuming he's got that because he has to go in with the courthouse, not with me. So
Okay. So out of my 3 prosecutors, between 2 in Butler and 1 in Green, I've given you all breakout rooms. Well, I didn't give Mr. Dean a breakout room, but I did the other half of the case.
And I am available, Your Honor, on any case that Mr. Patterson has.
Mr. Patterson, is there someone in court security you want to take up?
Judge James Abel.
Very well. If security can get James Abel. And Mr. Levitt is waiting on Mr. Regier, right?
I believe that to be the case, Your Honor.
All right, thank you, Mr. Levitt. James Abel, are you here?
I don't have him here at court security.
Oh, I thought he was in security. Well, who
No,
has,
James Abel's on the video.
do you want to take him up?
Yes, please, Judge.
We are on the record in 2024 CR 183, State of Kansas versus James Wilbert Abel III. Please announce appearances.
Your Honor, state appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of James Abel. Mr. Abel does appear via Zoom audio visual. Your Honor, it's my understanding the state was going to move to dismiss without prejudice.
Mr. Canfield, this is a criminal deprivation of property.
That is correct, Your Honor. State moves to dismiss without prejudice.
And there's no objection to that, Mr. Patterson, I presume?
No objection.
All right, Mr. Abel, they're dismissing this case, but they're doing it in such a fashion that if you give in any more reason, they will refile it. So keep that in mind.
Yes, ma'am. Thank you.
You're welcome. You may go at this time. Your bond is released. If there's a cash bond, you'll talk to the clerk about that. If it's with the bondsman, that's between you and the bondsman.
Yes, ma'am. I don't have to appear in court on Wednesday, do I?
No, you're free to go.
All right, thank you, ma'am.
You're welcome. Mr. Patterson
Timothy Baker, Your Honor.
will be on the record in 2023 CR 401, State of Kansas versus Timothy George Baker. Please announce appearances.
State appears by Devin Canfield.
Your Honor, Darren Patterson, appear on behalf of Timothy Baker. Mr. Baker does appear via Zoom audio visual. Judge, again, this is a case where the state, I believe, is going to make a motion to dismiss without prejudice, no objection.
Mr. Canfield,
That's correct, Your Honor. Move to dismiss without prejudice.
all right, Mr. Baker, same comment that I made to the gentleman before you. They can refile this if you give them any reason to. So make sure that you don't give them any reason. Also, Mr. Baker, make sure you give my clerk or legal assistant your current address. We apparently need that on file. Do you know how to chat that to them?
Yes.
All right, thank you. If there's nothing further, other than for that purpose, Mr. Baker is excused. And Mr. Patterson,
Judge, it looked like Mr. Paul's back. I don't know if you
all
want to
right,
take that up.
Mr. Paul, are we ready to reconvene on Ziner?
Yes, we are, Judge.
We're back on the record in Greenwood County 2024 TR 63, State of Kansas versus Lamont Williams Ziner, all parties as before. Mr. Paul, any announcements?
Yes, Judge. Mr. Ziner is going to plead guilty to the sole count of driving while suspended. It's a first offense.
Okay.
Our joint recommendation is going to be a 90-day suspended sentence for 6 months of non-reporting probation.
$100 fine.
Correct, Your Honor.
All right. Mr.
There would be a booking processing fee, $45, as well as the
150.
making it, yeah. And court cost and the court's determination as to reimbursement of appointed counsel fees.
Mr. Paul, are you appointed or retained on this?
I'm appointed judge, and Mr. Ziner right now is just working part-time at Sonic for $11 an hour. So I'd ask for the fees to be waived.
Mr. Ziner, how do you plead to driving while suspended? I'm sorry,
Guilty.
you're admitting that you did drive while your license was suspended,
Yes, I did.
and that was here in Greenwood County, Kansas?
Yes, it was, ma'am.
And do you remember what day that would have been approximately?
I don't remember the day exactly, but
Somewhere
that
since the
time.
first of the year?
yeah, it was at nighttime.
Okay. And your license was suspended while you were driving?
Yes,
Judge,
ma'am.
we would say that was on the 11th of January of 2024.
Okay, sounds right to you, Mr. Ziner?
Yes, it does.
All right, is anybody making you enter this plea today by threats or promises other than the agreement I've heard about?
No, they're not.
You understand that with this plea, you're giving up your right to that jury trial that we have scheduled, and you'll be found guilty and won't be able to appeal your conviction?
I understand.
All right, I find you guilty of driving while suspended. Your fine is $100 and your sentence is 90 days, but that is suspended with the condition that you successfully complete a 6-month non-reporting probation. You must pay court costs of $108, a booking fee of $45, and then you will, your attorney fees will be waived. How much time do you need to pay this? It's somewhere around $250-ish.
Yeah, Judge, it's 253, and we would ask for 120 days.
All right,
Part-time.
okay. You said 120 days?
Correct.
All right, I'm gonna give you 120 days to pay that, but make sure you pay a little bit every time you get a paycheck down there at Sonic.
Yeah.
All right, but it pay or appear, Mr. Dean, what date do you want
Yeah.
that?
Yes, Your Honor, I'm gonna assume that's gonna be, I think that's gonna be sometime on our February docket.
Okay, Missy.
Am I free to leave?
Not quite,
Not
Missy.
yet.
Yeah, how about February 14th at 11?
Valentine's Day. You have until Valentine's Day, February 14th, 2025 at 11 a.m. to have that paid, or you must be back here in court at the courthouse. And we will talk about the effect that that's going to have on your probation and whether you're going to have to serve a 90-day sentence or not.
So if I got it paid, then I don't have to come back?
Exactly.
Right.
You're exactly right.
Thank you.
You're welcome. You are excused.
Judge, that does it for me as well.
Okay, and
Your
that
Honor.
leaves,
I believe that completes my docket as well, Your Honor.
okay, so we do not have a Greenwood County case on the trial docket, Mr. Dean?
No, we do.
You got two of them that are still sitting there, Mr.
Oh,
Wallace and,
that was, okay, William Wallace and Michelle Turner. That's the
Correct.
two that wanted a trial.
Correct.
Okay. All right.
so
Missy.
if you need me back as far as making a determination, I'm just downstairs here at the commission meeting.
Okay, thank you. And Missy, help me to address that as soon as the docket's over.
And Judge, I do see Mr. Regier back.
Okay. Mr. Regier, let's take up Mr.
I believe Miss Delaschmidt, Your Honor.
Mr. Delaschmidt. One six, State of Kansas versus Charlene K. Delaschmidt. Please announce appearances.
Jared Regier on behalf of the state.
May it please the court, Miss Delaschmidt appears in person and by and through counsel Matthew Levitt. Judge, I spoke to
Yes,
Miss
I'm here.
Pierce.
Where is she? You're going to turn on your video, Ms. Delaschmidt. Do you see? Okay.
Yes, I'm here.
Go ahead, Mr. Levitt.
Judge, this case has been a rather unique case from the start. If you recall, we made announcements to the court that as of July 15th, Ms. Delaschmidt had applied to and had been denied diversion. That ultimately is what led to us continuing this out approximately 60 days on the court's calendar in order to get on a pretrial setting and jury trial setting. We have asked for reconsideration. Ms. Pierce and I were both desirous of potentially resolving this by means of diversion. If you recall, this pended for a while because the co-defendant in this case was incompetent to stand trial. It took the court or the county attorney's office some time to charge this, and then this was a matter that had multiple potential witnesses, because the crux of this was it all starting with a shots fired call and a fatality situation that obviously Ms. Delaschmidt is not charged with any conduct related to this. It's just the hosting. Long and short is that in talking to Ms. Pierce last week, and I hope that Mr. Regier has notes to back this up, we're desirous of setting this over because I have a offer that's been extended, but Ms. Delaschmidt's a little bit more complicated than a standard defendant because I've got to check what impact this is going to have on her professional licensing moving forward. She's now the primary caregiver of her husband. She's also the primary financial backbone of her familial unit. If we're trying to figure out a non-trial disposition that does not require bringing all of these witnesses in, potentially a very messy motion in limine situation regarding the nature of the call itself, but yet at the same time not putting her in a situation that ultimately she ends up losing her employment, and some of the things that we've been trying to do sort of become a fait accompli. I understand that puts us back out into February, but the parties are actively engaged in it, and again, this is a unique case that the fact pattern has just never lined up as normal.
Well, it allegedly happened July 1st of 2021. Now, like you said, it wasn't filed until sometime in 2023, but
The first appearance was actually October the 6th of 23. So,
In all
it,
this time, we haven't been able to check out all these effects and work out.
well, at least in part, no, Judge, because we didn't know the if-thans that were going to present themselves until we knew exactly the disposition on the diversion. And once we knew, because the idea of a dismissal of the case, even after a diversion situation, was that it wouldn't have no impact, is what it was shared with, which is part of the reason why we were very desirous of going that direction. It just didn't shake out properly due to eligibility. And we're told that again, that this comes from as high up as it gets, and this is just one that can't be diverted, even after going back to the well and attempting to make either mea culpas or mitigation offers or what have you. It's just not in the cards, is what I'm being told. So for that reason, if we're desirous of a non-trial disposition, we're now in the actively, if this charge, then this outcome, if this charge, then that outcome. And I don't have the answers to those yet.
Well, it seems to me I have those two in Greenwood County, but I would think this one would take precedence over those because of its age and because of its seriousness, although DUI is serious as well. Would she be ready to go to trial if I made this the prime this week?
I'd have to defer back to Miss Pierce, because it was my understanding that both Miss Pierce and myself were highly desirous of not trying this matter and being in a pole position, so to speak, because of the number of witnesses that I don't know that all of them have in fact been subpoenaed. Not saying that Miss Pierce ever is not in a ready position, but based upon the conversations, I don't know if I don't have that answer, Judge. I would have some concern about trying it with a pole position start on Wednesday from the defense perspective. And Miss Pierce made it sound like she would have a similar concern from the state's perspective.
Well, on July 15th, 2024, I said this case would go to trial this week. I'm going to put it in the stack and decide which one will go. And if you don't have your witnesses out, if Ms. Pierce doesn't, we'll have to talk about what we're going to do, because that is one that I really think we need to get resolved.
So are we planning on being in person on Wednesday then for a Wednesday start?
I will try to, yes, unless I've told 3 of you that now. So at the end of this docket, I'm going to have to decide who continues and which one's actually going to go.
And Your Honor, for what it's worth, I can tell the court I have had communications with Ms. Pierce regarding this case. At this point, insofar as saying the matter over for at least prospective disposition, the state does not have an objection to proceeding in that fashion.
To setting it over.
Yes, Your Honor.
If I thought maybe another, what is it, 5 months or 6 months, whatever, would resolve it, but I don't want to get to that point and still not be any closer to resolution. What kind of work does she do that this would affect her employment? Ms. Stella Schmid, where do you work?
I work for Progressive Insurance.
Are you an agent?
No, I'm a field specialist. I work out in the field, claims adjuster.
Okay. Mr. Levitt, Mr. Aguirre, I'm sorry to do this for you, but I will, at the end of this docket, evaluate all of these and then let you know. I will let you know which one is actually going to go.
And Judge, I appreciate that, understand the order of the court. I'm supposed to be on a Zoom for Barton County at 11. Is it possible to re-log on back after dealing with that? I don't think that one's going to take very long.
I don't expect you to re-log back. I will make a determination and then I will let you know.
I'll probably anticipate an email then.
Okay, yes. All right.
Thank you, Judge.
You're welcome. Thank you. You're excused, as is Ms. Stella Schmidt. Mr. Mr. Andrews, are we ready on yours?
Yes, Your Honor.
Which one?
If we take up Jeremy Buckley, Your Honor.
Yes. We are on the record in 2023 TR 419, State of Kansas versus Jeremy Gene Buckley. Please announce appearances.
Jared Regier on behalf of the state.
Joshua Andrews on behalf of Mr. Buckley, who is also present on the Zoom call.
How does Mr. Buckley intend to proceed today?
Your Honor, my understanding is we have entered into an agreement with the state. The state will be amending the charge to no driver's license in possession. Mr. Buckley will be entering a plea of guilty to that amended charge. There will be a joint sentencing recommendation of a $100 fine, $108 in court costs, a 90-day controlling sentence with 12 months non-reporting probation. And as a condition of his probation, he will serve a 10 days house arrest with work release.
Are you appointed or retained, Mr. Andrews?
I'm retained in this matter, Your Honor.
All right. Does he have his driver's license back?
He did. He reinstated his driver's license the day after the incident.
And that's your agreement, Mr. Regier?
Your Honor, if I may have a brief breakout room with counsel.
All right. Jen, if you'll put those two attorneys in a breakout room.
Judge, do we want to take up Mr. Patterson's cases while they're in a breakout room?
Well, I thought he made it sound like it was just going to be ever so brief, but it'd probably be more time consuming to split them again, but
Mr. Patterson just went into a breakout room.
that solves that. But we do have two other defense attorneys.
I've just recently learned that my case will be very brief.
Three defense attorneys. Thank you. All right. Who's your client?
It's Jesse Huff. And the reason it's going to be brief is I discovered this morning he's in the Sedgwick County Jail.
All right. Let's
and
take him up.
They can't get him on.
We're on the record in 2023.
Waiver that was in place before is continuing. Would I be incorrect in that assumption?
I would agree with that assumption.
All right, very good. Are the parties ready then to receive the verdict?
They are, and for the record, the people would be fine with Mr. Bernstein's assertion to the court about that, about his final option to be present for the verdict. While of course, the reading of the verdict is a critical stage of the trial, it has perhaps a different procedural effect that the others say in trusting Mr. Bernstein's assertion.
All right.
And likewise, ready for the verdict, Your Honor.
All right.
Like I said, I think it's going to be not guilty, although guilty wouldn't surprise me either.
Double check with Alan, but yeah, that's fine.
Don't worry, he's got a lot of other and much larger charges pending.
Oh,
He's not going anywhere.
We were just holding him
no matter what.
I thought transport wise, but no, I'll do them.
All rise for the jury. Seated. Your Honor, the jury is present.
Ladies and gentlemen, the court is of the understanding that you have reached a verdict. Do we have the verdict? And that back to the floor person. Ladies and gentlemen, the jury, who speaks for you? All right. And sir, you have reached a verdict. What is that verdict?
We have reached a verdict of not guilty.
All right. Would either side like the jury poll?
No, Your Honor.
No, Your Honor.
All right, very good. Ladies and gentlemen, I want to thank you very much for your service. We will send you back. I'll be back to formally excuse you momentarily. I know this has been a weird kind of journey having to come back, but I do appreciate your patience and helping us get through this. All right, thank you. Mr. Allen, you may take the jury.
Jury.
Well, there you have it. Not much of a surprise.
On this matter, is there anything else?
No, Your Honor.
All right,
Your Honor.
thank you. 14A stands in recess.
Yeah,
I finally heard back from Mr. Sweeney on Thursday.
all right. Is Mr. Canfield able to take that up, or do we need to wait for Mr. Regier as well?
Judge, I think we're gonna have to wait for Jared. He told me that he had all of these cases worked out, so
Wait.
I'm not sure.
Well, there's Mr. Weishman.
I don't
Mr.
see her.
Weishman, who do you have? Is he
Did they
ready
call her
to
case
go?
while we were over there?
Yes, he is, Your Honor. Thank you.
Remind me his name.
Raul Leedy.
That's my
And again,
concern.
Judge, we might need to wait for Mr. Regier.
I can get some cases going, Judge, if you want some.
Somebody go back 3 minutes and check.
Let's do what we can.
Okay. Jennifer Andrews, Your Honor.
We are on the record in 2024 CR 164, State of Kansas versus Jennifer Angel Andrews. Please announce appearances.
State appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Jennifer Andrews. Miss Andrews does appear via Zoom audio visual. Judge, in this case, state has agreed to amend the charge to 1 count of disorderly conduct without a DV tag. My client would be entering a plea of guilty to that charge.
And that's your agreement, Mr. Canfield?
Yes, Judge.
Miss Andrews, how do you plead to the amended charge of disorderly conduct?
No contest.
You're not admitting the charge, but you're not going to deny it and take it to trial either?
That's correct.
You know, you'll still most likely be found guilty, unable to appeal your conviction, and you'll be waiving your right to jury trial.
Yes.
Is anyone making you take this plea offer and enter this plea by any threats or promises other than the agreement itself?
No, ma'am.
Very well, Mr. Canfield, you have a factual basis?
Just a moment, Judge. I thought this was guilty. I'll just read through the affidavit.
Okay.
Jerry, the French toast. By the way, I like this thing.
Okay, someone, I'm picking up private conversation.
That was Jennifer Andrews, Your Honor. She might need to mute until she's ready to talk again.
Okay.
In Your Honor, should this case proceed to trial, the state would show through testimony or other evidence that on or about April 16th of 2024, around 8:30 in the morning, law enforcement went to the address of 742 East Wilson Drive in Towanda, Butler County, Kansas, where 2 individuals were in a verbal argument. One of those individuals was the defendant, and the defendant was using strong language, being very loud, with the purpose of intimidating or harassing or encouraging violent conduct.
All right, I find the defendant has freely and knowingly entered a no contest plea, and the state has provided a factual basis the court having jurisdiction, finding the defendant guilty of disorderly conduct without the DV tag. Recommendations?
State would recommend that there be no fine in this case. A 6-month underlying, suspended for a 6-month court services probation. And I will defer to defense on whether the no contact be dropped at this time. The state has no position.
Mr. Patterson?
Your Honor, we'd ask the court to adopt the recommendations. I am court appointed in this case. Judge, when I did talk to Mr. Canfield earlier, we talked about that the no contact would drop. They do have children in common. They're wanting to start basically getting things back to normal.
They haven't done any kind of therapy or counseling though, have they?
Judge, I don't believe so. And I guess also on Mr. Canfield's recommendations, it is disorderly conduct. So I think it would be 30 days instead of the 6 months.
Oh, yeah.
That's correct. Thank you. And Judge, I do recall speaking with Mr. Patterson about that. I would join in that the no contact be dropped.
All right, Ms. Andrews, I'm not going to order a fine.
Okay.
Tell me where you work, as I recall you work.
I do not work.
You haven't worked at all while this case was pending?
No.
But your husband has had the children?
Yes.
So
And I have them, they get dropped off at my mother-in-law's house. I have them, I have the children. I'm still their parent, stay at home.
Okay, so when he goes to work, he leaves the kids at his mother's house and you're living there, right?
Yes, that's correct.
All right, so no fine, 158 court costs, $60 supervision.
Okay.
I will waive the attorney fees. You will need to call probation as soon as this hearing is over at 316.
Okay.
322-4153.
Okay.
I'm going to make your probation 1 year rather than 6 months. Now you can get off early if you do well.
Okay.
You're going to have all standard conditions. And they will tell you when to have this paid, but I want monthly payments with the first payment due on October 30th and the 30th day of each month.
Okay.
You're not looking at much money, so you ought to be able to pay that. And as far as the contact, you can only start contact when the two of you are in marriage counseling and only as long as you're in marriage counseling.
So there needs to be marriage counseling. I just need to contact a marriage counselor. But until then, there's still no contact order.
Right. So get the first, when you get the first appointment, you go in for the first appointment, you can start having contact. As long as you do what the therapist tells you to do as far as when you go in. And you sign any and all releases, report services. Exciting. Confirm that you're doing the counseling and you're putting out the effort.
Okay.
Anything else, counsel, that we need to address?
No, Your Honor.
No, Your Honor.
All right, Ms. Andrews, go to your probation officer, call him or go there, one or the other right now.
Okay, thank you.
Yes.
You're welcome.
Go get some marriage counseling. Sure, it's got 100% failure rate,
Excuse me, Your Honor.
but it gets you off
Mr.
my call.
Patterson, I just wanted to let you know we had a latecomer, that Crispin Vasquez, that if you're going to need to visit with her yet.
I understand. I saw that.
Okay.
Judge, if they're not back yet, could we do Taylor Drake?
Yes. I can find Taylor Drake.
We're gonna go show him.
What? We are on the record in 23 TR 1826, State of Kansas versus Taylor Drake. Please announce appearances.
State appears by Devin Canfield.
Your Honor, Darren Patterson appear on behalf of Taylor Drake. Taylor Drake does appear personally via Zoom audio visual. Would announce at this time, Your Honor, Ms. Drake will enter plea of guilty to count 1, driving while suspended, 2nd, Class A misdemeanor. State's agreed to dismiss, no proof of insurance.
And that's your agreement, Mr. Canfield?
Yes, Your Honor.
Ms. Drake, how do you plead to driving while suspended after a prior conviction for the same?
Guilty.
You're admitting that you did do as alleged, you drove in Butler County on the dates stated at a time when your license was suspended,
Yes.
and you had a prior conviction for that?
Yes.
Is anyone making you enter this plea of guilty today by any threats or promises other than your plea agreement?
No.
And do you understand that this jury trial you have set today will be gone? You're giving up your right to trial, and you'll be found guilty and unable to appeal your conviction.
Yes.
And this is what you're wanting to do without anybody making you do it.
Yes.
And where were you driving at the time you were suspended?
In El Dorado, I'm not for sure like what street or anything.
Well, all of El Dorado's in Butler County, so I do have jurisdiction. And your license was suspended, right?
Right.
And you had been convicted of driving while suspended before that?
Yes.
All right. I will find that you have freely and voluntarily entered this plea. And this did happen May 23rd of 23?
Yes.
Okay. Finding you guilty of driving while suspended after a prior conviction. The other count, the insurance is dismissed, and recommendations for sentencing.
State would recommend a fine of $100, an 8-month underlying, suspended for a 12-month non-reporting probation, the 5-day sanction as complies with the statute, as well as any costs or fees.
Mr. Patterson, anything further?
Your Honor, we'd ask the court to adopt recommendations. Further, it is my understanding the state did not object to the 10-day house arrest in lieu of 5 days jail. We'd ask the court to consider that.
And attorney fees, are you?
I'm appointed in this case, Judge.
Okay. Ms. Drake, where do you work?
I don't work.
Why not?
I get SSI. I'm a stay-at-home mom.
Okay. Do you have a spouse or roommate that works?
My boyfriend works.
Does he help pay your bills?
Yes.
What do you get per month for SSI?
$9.43.
And how much does he make per month?
45. 4,500.
4,500?
Mhm.
And you get the benefit of that 4,500 in that he pays your rent and food and all of that?
Yes.
And what do you do with your money?
My money actually pays the rent, and he pays like the other bills that need to be paid.
And how many children do you have?
3.
His children?
Yes.
So you're all but legally married? I mean, you're
So
living
he
in
pays the
some
rent
kind of
and the other bills.
capacity?
Okay.
Yes.
He pays for everything. We get it.
All right. Your fine is $100. Your sentence is 8 months. Your non-reporting probation is 12 months. Your court costs are 108. I will waive your attorney fees. And do you want to serve 5 days in jail or 10 days house arrest?
10-day house arrest.
You must have that started within 1 week.
Oh, you see, they don't
must be
mention
under
that
house arrest
on
with
their
electronic
application.
monitoring. You are not to leave the house, not to pick up kids at school, not to do anything for 10 days.
Okay. So do I start my house arrest today?
No, within 7. You will call your probation officer today, though, at 316-322.
And Judge, you'd.
That's non-reporting. Okay, don't call your probation officer, but do call electronic monitoring and get that set up.
And I have that phone number, Judge, if she wants to write that down.
Okay, I'm ready.
It is 316-322-6600. 0021. Make sure they know I am your attorney when you call, so they send me verification you completed it.
Okay.
Yep.
Guys, I'm gonna make this a 1-year reporting.
You're sentenced to just keep doing what you're doing.
1-year reporting, which means add another $60 supervision. And call your probation officer as soon as we're through at 316-322-4153. With this being a second driving while suspended, with her having jail time, to make sure that she gets this paid, I want to go ahead and order that reporting. I think she needs the supervision. And I'm going to have them set up a payment plan if you can't pay it all in full at the beginning. Anything else, counsel?
No, Your Honor.
No, Your Honor.
All right, we'll be in recess. Ms. Drake, go call your probation officer.
Okay.
All right,
All right. Thank you.
you're welcome. All right, did I get Mr. Regier back? Did he leave again? There
I
he
am
is.
present at the court's leisure, Your Honor.
All right, Mr. Regier, who are you ready to take up?
I'm here to serve,
Your
Judge.
Honor, I will
Suck up.
respectfully refer to the court. I am prepared, whatever case the court may call.
How about Mr. Andrews' case? Mr. Andrews?
Your Honor, there was some confusion on my end regarding the plea. I need to just talk to my clients real fast to clarify we're still on board for the plea. If I could have a breakout room with Jeremy Buckley.
Okay,
Your Honor, it would appear that Mr. Beal is still present in the Zoom call. I'm not sure if the court will take up his case or not.
Mr. Bell, remind me your client's name again, I'm sorry.
Mr. Foster, Devin Foster,
And he
23.
is
still-
ready?
We are,
Weren't you trying to work out?
yeah, we're trying to work out a plea agreement, but we just got the recommendation for the sentencing and my client needs some time to think about it to work out the logistics.
Okay.
So I'm requesting a continuance.
All right, we're back on the record in 2023 TR 300112, State of Kansas versus Devin J. Foster, Jared Regier for the state, Terry Bell for the defendant, who is here in person. Mr. Bell, do you think we can put this back on a status hearing, or do we need to set it back on jury trial?
Devin, do you want to set it on a status docket?
I'm not sure what that means.
That would be like one of these dockets where we'd be entering the plea, or do you want to?
Yeah, that's fine.
All right, when do we have one? Is that December? Jen, do you have a status control docket for December?
December 23rd.
December 23rd at 9 a.m.
Thank you.
And then if we still can't work it out, then we can always put it on the February trial date.
Thank you.
You're welcome. All right, if there's nothing further, Mr. Foster and Mr. Bell are excused.
Your Honor, just a few finer points. That was December 23rd at 9.
Yes.
Thank you, Your Honor. I'm not sure if the court is, under these circumstances, intending on continuing the bond in this matter. It would appear that no drugs or alcohol was specifically ordered by Judge Crum back in November as a condition of the bond. It is the state's understanding, or state's recommendation rather, that should continue. Also, I have had the opportunity to communicate with my colleague, Mr. Sweeney, regarding this case. The state's understanding is that there was an attempt to reach out to counsel for the defense last week by phone, but that attempt was unsuccessful. As for today, I would tell the court that is the state's understanding that Mr. Sweeney was previously before another district judge today on an attempted murder case.
All right, well, I appreciate all of that, and Mr. Foster and Mr. Bell are excused at this time with the defendant's bond continuing all existing conditions and the added condition that he reappear December 23rd at 9 a.m.
Thank you, Your Honor.
Come here, Mama. Thank you.
Come. Thank you. No,
Somebody is needing to mute. All right, wasn't there someone else, Mr. Stang? Were you waiting on Mr. Regier?
Yes, I was, Your Honor.
All right.
Mr. Hoos. Timothy Hoos.
Okay. Remind me your client's name.
Timothy Hoos, Hoose.
All right, we are on the record in 2022, TR 3507, State of Kansas versus Timothy Edward Hoos. Please announce appearances.
Jared Regier on behalf of the state.
John Stang on behalf of Mr. Hoos, who is seated behind me in my office.
All right, and how does Mr. Hoos wish to proceed?
Well, as I was getting ready to say earlier, I talked to Mr. Sweeney on Thursday. He gave us an offer that Mr. Hoos is considering. However, I don't think he's going to go that route. My bigger concern, as I discussed with Mr. Sweeney, and I assume there's notes in the file, is Mr. Hoos is level 3, level 4 cancer. He's got 9 doctors, 2 navigators. He is on FMLA from work because he can't work right now. He's gone from 170 pounds down to about 110 to 115. He is on active chemotherapy every couple of weeks. He's got doctor's appointments, I believe, about every day to every other day. Mentally and physically, this is not a good time for him to go to trial. The added stress is going to hurt any chance of recovery. They're hopeful right now they can get his metabolism up to a point they can remove one of the tumors. So I would request a continuance. This is the very first time up. The reason for the delay was we were trying to find video and it took forever and a day to get a verification it didn't exist.
This is an old case. It goes back to 2022, but I understand your situation. Mr. Regier, your response?
Your Honor, I have no personal knowledge to the allegations presented by the counsel for the defense. If the court is prepared to continue this matter, the state would be requesting a ruling on the record as to whether such a continuance is to be assessed against the defense. If the court is prepared to continue the bond in this matter, I do not have any objections beyond that.
It would be at the defense request.
This matter is continued for jury trial at the defendant's request. Pre-trial is set for February 3rd, 2025, 9 a.m. by Zoom.
That's as close
Jury
as
trial is
sympathetic
set
as you're going to get.
February 5th and 6th, 2025.
I understand
9
why.
a.m. live in person.
Very good, Your Honor.
The
Thank you, Your Honor.
bond is continued with all conditions existing plus those added ones. And you're both welcome and you're excused, Mr. Stang and Mr. Hoos.
I thought he was going to ask for proof too.
You too.
I really did.
Mr. Weishman, how are we doing with your case? Are we ready on here?
Yes, I have Mr. Raul Leedy with me, Your Honor. We're ready to go.
Okay. We are on the record in 2023 CR 458, State of Kansas versus Raul Joseph Leedy. Please announce appearances.
Jared Regier on behalf of the state.
Good morning, Your Honor. Rocky Weichman on behalf of Raul Leedy, who appears behind me on the Zoom hearing.
And how does Mr. Leedy wish to proceed today?
Your Honor, we've reached a plea agreement whereby the only count in this case of assault will be amended to disorderly conduct. That would be KSA 21-6203A3, using fighting words or engaging in noisy conduct, tending reasonably to arouse alarm, anger, or resentment in others. My client will stipulate that that happened and agree that there's a factual basis for that happened on September 17th of 2023, and that it happened in Leon, Kansas, which is also in Butler County.
That's your agreement, Mr. Regier?
Your Honor, the state's understanding is that in exchange for a successful plea to this case, the state is prepared to amend count 1 to disorderly conduct under KSA 21-6203 subsection A3.
Mr. Leedy, how do you plead to the amended charge of disorderly conduct?
Guilty, Your Honor.
So you're admitting that, as your counsel said, you did use words, fighting words, or engage in noisy conduct that would reasonably cause arouse or alarm, anger, or resentment.
It wasn't me. Yes, Your Honor.
And this did happen in Leon, Kansas on September 17th of 2023.
Yes.
And who did you say these things in front of?
Your Honor, he was at a house and knocking on the door and yelling. And there
Okay.
was a text message before that, but I don't think he ever had any face-to-face contact with anybody that night.
Okay, so it could have upset the guy whose door was being banged on as well as anybody else hearing it, it sounds like.
Right.
And Your Honor, one thing I might also neglect to mention, I do not recall if this was officially addressed. Count one of the information, besides being originally charged
Yep.
under case 821-5412 subsection A, it does appear to include a domestic violence tag. The state's understanding is that the plea agreement did anticipate a plea to disorderly conduct as well as lacking a domestic violence tag.
All right, I do not find a domestic tag should apply. Having found the defendant guilty of disorderly conduct, recommendations for sentencing.
Your Honor, as a preliminary matter, is the court find that a guilty plea has been successfully entered in this case?
I do so find.
Thank you, Your Honor. Pursuant to plea negotiations, the state is recommending an anger management course in this matter. The state, pursuant to plea negotiations, is prepared to stay silent on the issue of the length of the course. I believe counsel has certain concerns regarding that, which he may make known to the court. I do not know the status of that. Beyond that, the state is recommending a 30-day underlying sentence, a 6 months reporting probation with a $60 probation fee, $158 court costs, a $300 fine, and no contact with the alleged victim in this matter.
$300 fine, 150, what was that for?
158 court costs, Your Honor, pursuant to the information, notwithstanding the amendment, this does appear to be charged as a criminal case.
And then you said there is a recommendation for supervision.
The state is recommending, besides a 30-day suspended sentence, 6 months reporting probation with all standard conditions, a $60 probation fee with no contact with the victim, as well as an anger management course. I believe pursuant to plea negotiations, I believe counsel intends to make certain arguments concerning the length of that particular anger management course.
Oh, I see. All right, Mr. Weissman, recommendations?
Well, I don't think we need anger management course in this case. If you look at the facts of this case, nobody ever made face-to-face contact. There were some text messages received by my client that upset him, and he went to the house. Nobody answered the door, and he left, and then he got charged with assault. This case has been pending for over a year now. There's been no allegations by anybody that Mr. Leedy has gotten angry in that whole year period. I don't see the need for an anger management course when we're talking about a Class C misdemeanor in this case. If the court does feel that anger management is needed, I would argue for the minimum 1-day anger management class. I would also argue that his probation be changed to non-reporting if you're going to make him do that, change to non-reporting after. I don't even know that. I mean, I'm arguing for 6 months non-reporting probation without any anger management. This case has been going on a year. Mr. Leedy wants to put it behind him. When they say no contact with the victim, I don't know what that means, because one of these victims apparently is his own brother. So he's had conversations with his dad. His brother wants to see this over with. Everybody wants to put it behind him. I think it was a big misunderstanding that night. And that's all I got to say, really.
Thank you.
I mean, I watched a case earlier on this docket this morning where an individual was charged with battery, pled to a disorderly, and the court did not order anger management in that case. That's a case where they were face to face and apparently came to blows. This is noisy conduct.
All right. As I look at the Odyssey screen, I don't see prior issues, although for some reason I thought, again, it's one of those where I thought I'd had him a while, but I think it's just the length of this case and the number of times he's appeared. At this point, I do order a $300 fine, $158 court costs, 30-day sentence, 6 months probation. I am going to order supervision with a $60 supervision fee. And I will give probation authority to require an evaluation to determine if he needs anger management, if they feel that they need to do that. At this point, I won't specifically order it. I will give discretion to probation. Probation is for 6 months. And if the brother wants to have contact, he can let his counsel know, and you can run that by probation also. Now, I'm giving them quite a bit of discretion, and they may have to refer back to me to shore up some of this, but that's what I'm going to order at this time. Are there any questions about that?
Your Honor, if the court is ordering as a condition of probation that there may be contact with the victim at the court services officer's discretion, I do not have anything further.
That's what I'm ordering. Mr. Weishman, anything further?
What is my client to do today to contact probation?
You can call them at 316-322-4153.
Thank you, Your Honor.
You're welcome. And if there's nothing further, Mr. Leedy and his counsel are excused.
Thank you, Judge.
You're welcome. Okay, other defense attorneys, who do we have besides Mr. Patterson? Mr. Andrews, who do we need to call again?
Jeremy Buckley, Your Honor.
We are back on the record in 2023 TR 419, State of Kansas versus Jeremy Gene Buckley. I think we've already called appearances, but again, for the record, please, if you'd state them.
Jared Begier on behalf of the state.
Joshua Andrews on behalf of Mr. Buckley.
Who also appears where? Where'd he go? Where's Mr. Buckley?
Is he, I'm wondering if he's still in the breakout room. Jim, could you close that breakout room? I think he may have not realized he had to leave the breakout room.
Why are you unnecessarily wasting the judicial time of this court?
Sorry about that, Your Honor.
No, that's all right. All right, Jeremy Buckley joins us. How do you want to proceed, Mr. Andrews?
Your Honor, I had misspoke earlier regarding the plea that we agreed to. Mr. Buckley will actually be entering a plea to the charge of no driver's license pursuant to KSA 8-235. But I believe that everything else that I had announced regarding the plea is still consistent with the agreement reached with the state.
All right, Mr. Regier, do you agree with that?
Your Honor, the state's understanding of the plea in this particular case, while I do not normally do this, is that in exchange for a plea in this matter, the state is prepared to amend count 1 to no valid driver's license under KSA 8-235.
Okay. Mr. Buckley, how do you plead to driving a vehicle in Butler County, Kansas on December 7th, 2022 without a valid license?
Guilty.
You're admitting that you did do that?
Yes, ma'am.
Is anyone making you enter this admission by any threats or promises other than the plea agreement?
No, ma'am.
Do you understand you're giving up your right to a trial? And you'll be
Yes.
found guilty and unable to appeal the conviction?
Yes, ma'am.
Okay. And where were you doing this driving in Butler County on December 7th, 2022?
I was headed to work, and it actually happened just a couple miles down the road from my house.
And where would that be?
Out off of 30th, out by Tawanda. between Towanda and 96 by El Dorado.
Okay. I do find jurisdiction. I find your plea is freely and knowingly entered, finding you guilty of the amended charge of KSA 8235. I do fine you $100 and assess court costs of $108. You will be granted a 90-day sentence. You're granted 12 months non-reporting probation with the condition that you serve 10 days house arrest. You're to start that within 7 days. Make sure you're on electronic monitoring within 7 days. Make sure you get proof of that to the county attorney and to Mr. Andrews. That's a condition of your probation. How long do you need to pay the total of $208?
I'll pay it this Thursday.
All right. You'll need to pay that in person or in the mail. Anything else we need to address, counsel?
Your Honor, if the court is ordering that the 10 days house arrest be commenced within 7 days, is the court making any orders concerning electronic monitoring or work release? I do not believe that was discussed during the context. of the meeting.
Okay. Where do you work?
Spirit Air Systems.
All right. You will start that within 7 days. You will have electronic monitoring on. For these 10 days, you are not to leave your house except for work and court appointments. That's it. Mr. Regier, you're retained. Mr. Andrews, you're retained.
I am, yes, Your Honor.
Okay. Anything else we need to address?
Not to my knowledge, Judge.
All right, Mr. Buckley, you are excused.
Thank you, ma'am.
You're welcome. Mr. Andrews, do you have anyone else, another defendant?
Yes, Your Honor. Next, I would take up this James Squire.
You're on the record in both 2023 CR 434 and 23 TR 3663, each captioned State of Kansas versus James Patrick Squire. Please announce appearances.
Jared Regier on behalf of the state.
Joshua Andrews on behalf of James Squire, who is also present.
How does he wish to proceed, Mr. Andrews?
My understanding is that we've reached an agreement with the state. Mr. Squire will enter a plea of guilty to the seatbelt violation and an amended charge of no valid driver's license in 2024 TR 3663. And in exchange, the state will dismiss 2023 CR 434 in its entirety.
Okay, seatbelt is count one.
I don't remember. I'm sorry, Your Honor.
No problem. Let me see here. That's in 336. Seatbelt is count one, and DL, that's an amended charge of no DL. That's count two.
Yes, Your Honor.
Is that 8244 or 8235?
8235, Your Honor.
Thank you. That is your plea agreement, Mr. Regier?
That is the state's understanding, Your Honor. Upon successful entry of pleas to count one and amended count two, the state is prepared to dismiss 23 CR 434 pursuant to plea negotiations.
Okay. Now, Mr. Squire, you're gonna have to find a place and stop so you're not moving around. But I don't want you frozen, so you ready?
Sorry, there's a plane flying overhead. I couldn't hear you.
All right, you need to find a spot and stay put. Don't be moving around. Are you almost to that spot where you can quit moving?
Yeah. Yes.
All right, the attorneys tell me that you want to plead in the traffic case 23 TR 3663. You want to plead guilty to count one, not wearing a seatbelt, and count two, driving without a valid driver's license. How do you plead?
No contest or guilty.
Okay, well, which is it? It's up to you.
Guilty.
All right, you want to admit that you did do those things as charged? Do you want to admit that? By
Yes.
pleading guilty, you've admitted? Is anyone making you enter this plea of guilty today by any threat or promise?
No.
And do you understand that with this plea, you're giving up your right to trial? You will be found guilty and you won't be able to appeal that conviction.
Yes.
And where were you driving this automobile without a seat belt and without a license on December 21st of 2023?
Where was I? I was in El Dorado,
Okay. I
right
find
there
that,
by homes.
okay, I find I have jurisdiction. I find that you have freely and voluntarily entered this plea and that a factual basis exists. Finding the defendant guilty, recommendations for sentencing.
Yes, Your Honor, if the court is successfully finding that guilty pleas have been entered to counts 1 and amended count 2 in the 23 TR 3663 case, the state would move to dismiss the CR case pursuant to plea negotiations. As insofar as the issue of disposition of the TR case is concerned, for count 1, the state is recommending the statutory fine of $30, which does not appear to include court costs based on my understanding of the statute. For the amended count 2, the state is recommending a $200 fine, $108 court costs, a 6-month underlying sentence, and 12 months of non-reporting probation. I do not have any knowledge as to whether Mr. Andrews is appointed to that particular case, but of course I will respectfully defer to the court as to that particular issue.
What did you recommend for an underlying sentence on count 2?
6 months, Your Honor. The state's understanding is that the amended count 2 is a class B misdemeanor within the meaning of the statute.
Yes. Mr. Andrews, your recommendations?
Your Honor, I would join in the recommendations of the state, a $30 fine on the seatbelt violation, $200 fine on the no driver's license in possession, or no valid driver's license, I apologize. 6-month controlling sentence with 12 months non-reporting probation. I am appointed on this matter.
Remind me, Mr. Squire, where you work?
Meese Construction in Wichita.
And do they have you work a full week, a full 40-hour week at least?
Yeah, if it doesn't rain.
Okay, and do they pay
If
you
it
a
rains,
good
we
wage?
can't work.
What do
Do they pay me a what?
What did they pay you? Do they pay you a good wage?
Yeah, 18 an hour. Well, my ex-wife gets half of it, but
For child support and such? I'm going to waive your attorney fees. You will be on count 1 required to pay a $30 fine, $200 fine on count 2, $108 in court costs for a total due of $368. Your sentence controlling is 6 months. If you don't want to do 6 months in jail, make sure that you're successful on a 12-month non-reporting probation. To be successful, have no violations of the law and get this paid. And how much time do you need to pay the $368?
well, I say by the end of the year.
90 days, would that work?
Yeah.
90 days to pay, or you'll get your license taken away. And did you get your license back?
Yes.
All right, we'll make sure this is paid, or they'll take your license again and they'll send a collection agent after you, and you don't need all that. Anything else, Mr. Regier?
Your Honor, is the court ordering that the case shall be paid in full within 60 days?
I gave him 90.
Very good, Your Honor.
Right.
And one other thing I must respectfully advise the court of, in accordance with my duty of candor as an officer of the court, I believe the court had ordered a $60 fine for count 1. The state's understanding is this is a case where KSA 82504 subsection A1 applies, which provides, quote, persons violating KSA 82503 A1 and Amendment 2 shall be fined $30 and no court costs.
All right, well, I thought I said 30. I meant to say 30. So it is 30 on count 1 and 200 on count too. So thank
Very
you,
good, Your
Mr. Regier. And Mr. Squire, you may go at this time. Good luck to you, sir. Okay, Mr. Andrews, anyone else?
One more, Your Honor, Kristen Huerta.
Remind me, that's an H, right?
Oh, it's
Yes,
on.
and I'm wondering if she is still in an earlier break. Well, no, she left that breakout room, I thought.
Anybody
But I'm
know
not-
where Miss Huerta went?
She's still
Oh,
in the pickup
actually
room.
had her in the waiting room because she was being disruptive with the chat.
Getting disruptive with what?
On the chat.
She's back, baby.
Oh, yeah, sending out chats. Let's see if we can get her back. There she is. All right. Now, Miss Huerta, you can start your audio so we can hear you.
I don't know why we have Spanish subtitles. I thought I
Click
checked
on the little
myself.
red thing that looks like a microphone with a line through it.
It's not me.
Okay. Hi.
On the record in 2022, CR 458, State of Kansas versus Kristen Nicole Huerta. Please announce appearances.
Jared Regier on behalf of the state, Your Honor.
Joshua Andrews on behalf of Ms. Huerta, who is also present.
And how does she wish to proceed?
Your Honor, if I understood correctly during my brief breakout room with Ms. Huerta, she is wanting to pursue the possibility of additional discovery. So I believe she is asking me to request a continuance of the jury trial setting.
Well, what kind of discovery is she not, that she doesn't have that she thinks she needs?
She had indicated that there may be some phone records that would be beneficial to her case, Your Honor.
Mm-hmm.
What kind of phone records?
Cell phone records for the alleged victim and another witness.
Do you have any such records, Mr. Regier, or can you get them easily available or readily available?
Your Honor,
Your
I
Honor,
can-
don't believe these would be records in the, my understanding is from, if I understood correctly, these are not records that are in the state's possession, but instead she believes that the phone company would be able to provide these records.
Well, let's make sure, Miss Huerta, I don't want her, if she's got a legitimate defense, I want her to have it. But if she's just going off on a tangent,
She's had
I
enough
don't want
time.
that. The burden is on the proof. The burden or proof is on the defense of the state. The state has to prove that she either harassed someone by a telephone device or she didn't. So I would think that that would have to be records the state would produce. I failed to see what it is that would justify delaying this. This allegedly happened, as council knows, September 19th, 2022. 2 years ago, and then we'll have to move it into February. In all candor, Mr. Andrews, you believe these are records that could help your defense, or they're just records she wants?
I cannot answer that based on the brief conversation I had with Ms. Huerta. My understanding is she believes that it would show it would put the conversation that is the text messages that were provided by the state in a better context, but I've not had the opportunity to discuss with her what pleas are in those records that would put that in that context. So I can't answer as to whether these records would turn out to be helpful to the defense or not.
Well, she's charged with telephone harassment, and just in the time she's been here, she's had to be put in the waiting room because she was so busy sending everything to us. Here's one that
Oh, I want to hear this.
Mr. Andrews, have you seen these?
I've seen many of them, Your Honor.
Read them.
Like here's, what's this one about 3/21/1957 question mark? Marcella 75, something around 199X.
Your Honor, I don't know. Ms. Bertha has had a competency evaluation already. It was determined that she was competent to stay in trial.
Right, right.
Believe that there were indications that she does have some mental health issues. She is under guardianship.
I like how she she asked the attorney to explain
State's
it.
position, where did she go, Miss?
I have to use, can I take a quick break, bathroom break? I'm sorry, I'm pregnant. I didn't expect you guys to be back on here, so suddenly my
I
case.
can't, oh, hold up, I can't hear you. Get back on screen.
Sorry, I didn't expect to be back so suddenly. My caseworker was sitting in my chair to guard the computer for me. I need to go to the restroom if I might, because I'm pregnant and I didn't expect you guys to intervene or you know.
Well, I need to get Mr. Andrews back to work. It's almost lunch.
Yeah, okay, yeah, okay.
But, okay, so you've got a case manager with you.
Let's transfer on to my caseworker.
What?
My caseworkers,
Your caseworker's here, and you're pregnant. How far along are you?
I'm 26 weeks, I believe.
And are you married to the father?
Are we married?
Right?
No, we're not married currently.
And you don't intend to be?
Really?
I don't know what he feels about the situation. I mean, we've been best friends since preschool, so.
Okay, what's his name?
I'd rather just not divulge that information.
All right. Mr. Regier, what's the state's position on this request for continuance of this case that is so old?
Well, Your Honor, in all candor, the state does have some concerns with saying this over yet again. I am showing that previously back in February, subpoenas were issued and witnesses were served for a jury trial setting back on February 7th. Here we are again, and if you'll pardon the conjecture, essentially the same position as we were as well. And I am showing that for the jury trial setting this week, subpoenas have been issued in that hearing as well. So if the court is inclined to set this matter over, the state would request that its objections be noted on the record, and the state is respectfully insisting that the court make a finding as to whether or not such a continuance is to be assessed against the defense in this matter. Beyond that, the state is prepared to proceed to trial.
Mr. Regier, Mr. Andrews, I'm going to do this one like I've done a couple others. I'm going to put you in the stack of no continuance until I figure out, you'll be the fourth, but I'm going to reevaluate after this docket is over and decide which of you will go and which of you will continue. So at this point, continuance denied, and then I will let you know based on my evaluation of which one is priority at that time. So Ms. Huerta, you need to be ready to go to trial, and then I will let your counsel know which one of you are going to be the final prime case.
Okay, sure.
Because you could have gotten those records, you could have gotten those back.
Well, I requested them at the beginning of this entire thing, so I don't understand where there was a lag in communication. I don't know if the message didn't get passed from the front desk back to him, or
I don't know
exactly
either,
the
but
communication delay was, but
who is she reportedly harassed, or who did she harass? Whose name is the victim?
Her father, Your Honor.
Her father. All right, I'm going to continue the bond you're on with all existing conditions, and I will let your attorney know if you need to be ready for trial Wednesday or not.
okay, yes, ma'am. Yes, Your Honor.
You may go. Mr. Andrews, you're excused too, if that's your last one.
It was. Thank you, Your Honor.
You're welcome.
May I have permission to leave the room?
You have permission to leave the room.
Thank you.
You're welcome. Who do you have, Deputy Caulfield?
Well, I have one pro se here, which is Kyle Goebel, and then I have 10 of Mr. Patterson's.
Do this today, Your Honor. My health is in jeopardy right now.
What's up?
I have IBS, irritable bowel syndrome,
Mhm.
and what's been going on?
Very stressful.
I'm bleeding inside, ma'am.
Well, there you have it. We had to wait a while, but it was worth it. It was worth it. Where to pull the IBS? We got a pregnancy. I don't know if we believe the pregnancy. I'm not saying she's not pregnant. I don't know, but like it just seems convenient. She seemed like, I could be reading it wrong, but I got the sense that she wasn't taking it seriously, like she thought it was a joke. But maybe I mean, it's certainly possible. It's certainly, it's certainly more likely than say tonsil twins. Just to give it, put it on the crazy reference scale. I can't remember that woman's name. Was it the woman who was harassing Eckert? Oh, whatever her name was. That's a bad sign. We just watched a Dubois Huerta appearance and decided that you're crazier than that. Laura Owens. There we go. Laura Owens. Thank you. I don't know what she's doing. I'm sure she's accusing somebody else of knocking her up right now. Without, she doesn't even, go through the hassle of actually getting pregnant. She just likes to throw the allegation around. Wild times. All right. Well, I don't know. This turned into a 3-hour stream, but I don't care. We achieved the objectives. We saw the remainder of the Bloom trial. We already got the verdict, and we got the other one in Judge Webster's room that we wanted to see. It took us a while, but we got it all done. Thank you all for coming out. I don't know what I think I'll just title it Bloom Not Guilty. Yeah. I think that's the only title for the stream. But somehow I got to work Huerta into the thumbnail. I think I'm just gonna throw her into the room, so she'll be in the room with Simpson and not Bloom. Bloom's attorney, I guess. Unfortunately, I think the right thing happened as a matter of law with the Bloom case. I'd like to see him get rung up because he's a nasty individual and he deserves it in sort of the karmic sense. But as a matter of law, they just didn't quite have it. And again, that is no knock on the prosecutor. She did very well with the facts she had. It's just that's where you were. And the defense did a nice job defending him and beat the right point, which is intent. So that whole thing, while sort of a frustrating result, I think is the correct one. And that doesn't really bother me. He'll get rung up on the more serious charges. And he also can't behave while he's in custody, so he'll get more charges while he's in custody because he's him. That's what he does. All right. Thank you all for coming out. I appreciate it. I will see you all soon.